May I respectfully invite Shri P. Kanan, IPS, IG Bihar, to grace the dais. May I also invite Shri Subhash Chandra Sharma, Director Administration, Bihar Judicial Academy, to kindly grace the dais. We shall now proceed with the felicitation of our esteemed dignitaries. I request Shri Bharat Bhushan Bhasin, Director, Bihar Judicial Academy, to kindly felicitate Honorable Mrs. Justice Soni Srivastav, Judge, Patna High Court, with a planter and memento. I request Shri Nishikant Thakur, Additional Director, Bihar Judicial Academy, to felicitate Honorable Mr. Justice Ajit Kumar, Judge, Patna High Court, with a planter and memento. I again request Shri Nishikant Thakur, Additional Director, Bihar Judicial Academy, to kindly felicitate P. Kanan, IPS, IG Bihar, with a planter and memento. I request Shri Mukesh Kumar, Deputy Director, Bihar Judicial Academy, to felicitate Shri Subhash Chandra Sharma, Director Administration, Bihar Judicial Academy, with a planter and memento. The floor is now handed over to the respected Chair, Honorable Mrs. Justice Soni Srivastav, Judge, Patna High Court, to kindly moderate the third technical session. Ladyship.
Hi, thanks. Honorable Justice Rajiv Ranjan Prasad, JD2 Patna High Court, as also the Chairman of the Bihar Judicial Academy. Since I see a few of my colleagues right now, let me also name Honorable Justice Sandeep Kumar, Honorable Justice Anupma Chakravarti, Honorable Justice Alok Sinha, and Honorable Justice Saurendra Pandey. All other colleagues who have probably joined online. My co-chair, Justice Ajit Kumar, the two resource persons, Mr. P. Kanan, IG of Police Provisions, and Mr. Subhash Chandra Sharma, the Director, Administration, Bihar Judicial Academy. I also extend a very warm good morning to all the judicial officers, the police officers, Mr. B. Rajendra, the Director of BIPARD, and all the other dignitaries who are present here today in this auditorium. It is indeed a privilege to welcome all the distinguished participants to this technical session on inter-agency coordination mechanisms to avoid delays, from investigation to conclusion of trial. The theme of today's deliberation is both timely and significant, particularly in the backdrop of the recently enacted criminal laws, which seek to usher a more efficient, technology-driven, and citizen-centric criminal justice system. The administration of criminal justice is not the responsibility of any single institution. I think we all know that. It is a coordinated endeavor involving the police, the prosecution, the forensic experts, the prison authorities, legal services institutions, and ultimately the judiciary. The effectiveness of the system depends not merely upon the efficiency of each institution individually, but upon the strength of the coordination between them. As our ancient wisdom reminds us, Karya Purushakarein Siddhyati, which is success is achieved through collective effort and diligent action. This philosophy is equally reflected in the recommendations of the Justice V.S. Malimat Committee on reforms of the criminal justice system, which emphasized that the criminal justice process can succeed only when all its constituent agencies function in close coordination. I think that is what we are talking about today. The delays and inefficiencies are seldom attributable to a single institution. Rather, they arise from systemic gaps across the entire justice chain. The recently enacted criminal laws reflect this very philosophy. They seek not merely to replace the existing statutes, but to transform the manner in which criminal justice is administered by introducing statutory timelines, greater use of technology, digital processes, and stronger forensic support. These reforms are intended to make the system more efficient, transparent, and responsive, while preserving the fundamental principles of fairness and due process. However, the legislation alone cannot achieve these objectives. Its success ultimately depends upon the seamless functioning of every stakeholder. Comparative studies on interagency coordination also indicate that meaningful coordination must operate at three interconnected levels, and these three levels are the strategic, police, and operational. Now, while strategic coordination provides a common vision, policy coordination ensures institutional coherence, and the operational coordination facilitates timely information sharing and effective day-to-day collaboration. A delay at any one stage, inevitably affects every subsequent stage of the criminal process, thereby impacting the quality and timeliness of justice. The experience of our courts also reminds us that pendency is not merely a judicial concern. Delays occur during investigation, forensic examination, filing of charge sheets, service of summons, production of witnesses, or execution of processes inevitably affect the pace of trials. Timely justice, therefore, is a shared institutional responsibility. We are all the branches, we are all responsible for any delay that has occurred, and timely justice should be the goal of all of us together. In this context, the words of Benjamin N. Cardozo remain particularly relevant. Justice, though due to the accused, is due to the accuser also. This simple yet profound observation reminds us that an efficient criminal justice system must safeguard the rights of every stakeholder while ensuring that justice is delivered fairly and without avoidable delay. Our constitutional jurisprudence has consistently recognized that the right to a speedy trial is an integral facet of Article 21 of the Constitution. So today's session provides an excellent opportunity to exchange practical experiences, identify institutional challenges, and explore workable solutions that can strengthen coordination from the stage of investigation until the conclusion of trial. Our discussions will also highlight that the new criminal laws envisage a modern, technology-based criminal justice system through digital records, electronic communication, forensic integration, and adherence to statutory timelines. These reforms will achieve their intended purpose only and only when supported by adequate infrastructure, continuous capacity building, and sustained institutional commitment. Equally important is the recognition that formal mechanisms alone are seldom sufficient. While statutory provisions, standard operating procedures, and institutional frameworks provide the necessary foundation, lasting coordination ultimately depends upon regular communication, mutual trust, joint capacity building, and a shared institutional commitment to the administration of justice. Better coordination, timely exchange of information, and clearly defined responsibilities can substantially reduce avoidable delays while enhancing both the quality and credibility of criminal justice administration. Ultimately, the objective is not merely the expeditious disposal of cases, but the delivery of justice that is fair, transparent, and consistent with constitutional values. Speed and fairness, we should remember, are not competing goals. They are complementary pillars of an effective criminal justice system. I am confident that today's deliberations will generate meaningful insights and practical recommendations that will further strengthen institutional coordination and contribute to a more efficient, responsive, and citizen-centric criminal justice system. With these words, I extend a very warm welcome to all the distinguished participants to commence the presentation. To begin with, let me invite Mr. P. Kanan, who is the Inspector General of Police Provisions, an accomplished 205 batch of IPS officer of Bihar cadre, hailing from Tamil Nadu. Throughout his career, he has held vital field assignments, serving as the SSP Gaya, Katihar, Begusarai, and Munger. He has been the DIG of Saran and Shahabad ranges, recognized for his administrative acumen, his exemplary dedication to public service and systemic reforms, earned him the prestigious Police Medal for meritorious service. So over to you, Mr. P. Kanan.
Honorable Chair, Honorable Co-Chair, Honorable Justices, learned judicial officers, my colleagues and friends, a very good morning. As we know, the BNSS aims to reform the criminal justice system. During the last 2 years, all the stakeholders have made efforts to implement these reforms. One important aspect of the reform efforts is interagency coordination. The BNSS, as we all know, prescribes timelines. However, the timelines can be met only when all the stakeholders work together. At first glance, the provisions of BNSS may appear to deal with different subjects like timelines, forensic investigation, electronic evidence, technology, etc. But if we look at the provisions closely, they all have one thing in common. Each of the reform measures requires the institutions to work together. For example, mandatory forensic investigation requires coordination between the police, forensic laboratories, and experts. Collection of evidence depends upon timely responses from banks, telecom service providers, government departments, intermediaries, etc. Similarly, timely return of property to victims and conclusion of trial require coordinated action by police, prosecution, courts, and other authorities. So, the timelines cannot be achieved if response is delayed by any stakeholder at any stage. Therefore, coordination among the stakeholders is central to BNSS. What does the BNSS actually do? When we examine the provisions of the BNSS, we find that the law requires one authority to interact with other. It requires authorities to seek approvals, forward information, obtain reports, collect records, transmit documents electronically, execute court processes, and return property to victims. To put in perspective, the BNSS creates several points where one institution depends upon another for timely completion of its statutory functions. So the law not only prescribes what is to be done, but also assumes that the institutions will work together in a coordinated manner. Whether it is the police, forensic science laboratories, prosecution, courts, or service providers, timely performance by one agency is the function of timely response by another. The BNSS creates legal framework for coordinated functioning. But we have efficiency concerns in coordination because coordination efforts are not supported by administrative procedures in place. These mechanisms may be in the form of rules, standard operating procedures, standing orders, instructions, or availability of digital platforms. In our experience, the challenge today is not the absence of legal provisions. We do have adequate legal provisions in place, but the challenge is that many of the administrative mechanisms are not available across institutions. For example, even today, the forensic science laboratories in Bihar do not have their manual. Different departments follow different procedures. Often there is no visibility regarding the status of requests sent to other stakeholders for their response. As a result, delays occur. BNSS tells what needs to be done. However, the stakeholder departments are required to determine how it should be done. For example, if an investigating officer requires an information from your department, who should receive the request? What is the prescribed format? Can it be sent electronically? Who is the competent authority to act upon? What's the timeline for response? How should the response be communicated? Who monitors delay? These are not the legal questions, these are administrative questions. Unless these questions are answered through procedures and workflows, meeting the mandatory timelines will be difficult. So the next phase of implementation should be about creating processes that enable the stakeholders to work together. The coordination issues that we experience today are not necessarily because institutions are unwilling to cooperate. In many cases, coordination problems arise because the criminal justice process has actually changed much faster than the administrative procedures in place. Many mandatory provisions have been newly introduced by the BNSS, but the departments continue to follow old procedures, manuals, formats, and their communication channels. Electronic platforms are not available in every department to interact. In many cases, there are no prescribed timelines for response or mechanism to monitor the progress made to reply to the requests received from the criminal justice stakeholders. So, even one agency tries to act promptly, another agency whose internal processes are not aligned with the requirements of BNSS may delay the process. This is why the next phase of implementation should focus on reviewing the departmental procedures, simplifying the workflows, and strengthening digital coordination across institutions. The first stage where interagency coordination in the criminal justice process assumes significance is the receiving of information and commencement of investigation. Today, as per BNSS, information can be received physically at the police station, electronically, from another police station as a zero FIR, from the courts, or even from another government department. The BNSS recognizes many of these modes and expects timely action. However, in practice, several coordination issues arise. A zero FIR has to reach the jurisdictional police station without delay. Preliminary inquiries need to be completed within the prescribed time limit. The information received has to be acknowledged, assigned to the authority competent, and acted upon within the prescribed time limit. Many of these activities still depend upon manual communication, telephone calls, or physical correspondence. As a result, there are delays in transfers, uncertainty regarding receipt, and duplicity in inquiries. These are basically workflow-related issues rather than legal issues. These can be addressed through processes such as electronic transfer of cases, automatic acknowledgements, timeline monitoring, and automatic alerts. These mechanisms can reduce delays and also improve the accountability of stakeholders. The crime scene is the best example of why interagency coordination is indispensable under the BNSS. Today, investigation at the crime scene requires timely coordination with forensic experts, medical officers, and other specialists. The quality of evidence collected at the crime scene often determines the outcome of the investigation and ultimately the trial. Our experience shows that there are often delays in reaching the crime scene, delay in securing expert assistance, improper preservation of the scene, deficiencies in documentation, or delay in forwarding the exhibits for forensic examination. Such deficiencies may affect the evidentiary value of the material collected, but many of these issues can be addressed through creating workflow processes, standard operating procedures for crime scene management, digital requisition for forensic teams, and online monitoring of status of the exhibits in the forensic science laboratories. Here the objective should be that every stakeholder involved in the crime scene processing has clarity regarding his role, responsibility, and timeline, and that the progress of every requisition remains visible until its completion. This is very, very important. Now, a significant part of investigation depends upon information that is available with other stakeholders or other organizations. An investigating officer may require bank accounts, telecom records, revenue records, hospital records, information from internet platforms, intermediaries, etc. Obtaining such information is often not as a simple process. Different organizations have different procedures, different formats, and different competent authorities. Some departments have facilities to receive requests electronically, while others continue to rely upon physical correspondence. In many cases, there are no prescribed timelines for response, and once a request is sent, there is very little visibility regarding its status. These delays are not always because information is not available, but because the administrative mechanisms for receiving, processing, and responding to requests have not been standardized across institutions. Going forward, there is a need for common request formats, designated nodal officers, facilities for electronic receipt and transmission of requests, and tracking for pending requests. As investigations increasingly rely on electronic evidence, another area that deserves attention is the manner in which government records are created, maintained, and shared with investigating agencies. Today, investigators and courts often rely upon electronic notifications, revenue records, land records, municipal records, and other official documents. Although these documents are available in electronic form, different departments often follow different formats and authentication procedures. In many cases, there is no uniform process for verification of authenticity or preserving these records. As a result, time is often spent in establishing the genuineness of records that are otherwise maintained by the government itself. This not only delays investigation, but may also delay the trial. So there is need to standardize the manner in which government electronic records are generated, authenticated, preserved, and transmitted. Common document standards, digital signatures, secure audit trails, and designated nodal officers can improve confidence in the electronic records and reduce unnecessary delays. Ultimately, government records should move seamlessly and securely from one department to another, and whenever required, to the investigating agency and to the court without repeated verification at every stage. This issue needs to be addressed. So far, rules have not been framed in this regard. Electronic evidence has become an integral part of every investigation now. Mobile phones, CCTV footages, bank transactions, emails, social media accounts, cloud storage, and digital platforms now constitute important sources of electronic evidence. Unlike conventional records, electronic records have their own shortcomings. Data may be deleted or overwritten within a short period. It may be stored across multiple servers or with different service providers. Data is also stored outside Indian jurisdiction. Also, there are concerns relating to authentication and integrity of electronic records. From the perspective of interagency coordination, this requires timely action. Preservation requests must reach the service providers before the data is lost. Requests for disclosure should follow standard formats. Departments should identify nodal officers to process the requests timely. Digital records should be transmitted securely, and the chain of custody should remain intact until the evidence is produced before the honorable courts. As technology continues to evolve, particularly in the context of artificial intelligence, these challenges are likely to become more complex in future. Therefore, creating workflow for collection, preservation, and sharing of electronic evidence should be a priority area. Another serious coordination issue is collection of evidence from other jurisdictions. Many investigations today extend beyond the jurisdiction of the police station and even the country. In cyber offenses, financial crimes, and organized crimes, evidence may be available with another state or a service provider located outside India. Obtaining such evidence is often a time-consuming and complex legal process. Different states follow different work procedures. Central agencies have their own protocols. Foreign jurisdictions operate under different legal systems. And global service providers have separate disclosure policies and legal requirements. Secondly, there is also the practical issue of preservation. Electronic evidences are often volatile. Unless preservation requests are sent timely, the evidence may be lost even before the formal legal process is completed. These challenges cannot be addressed by the investigating agency alone. These require well-defined coordination mechanisms at every level, designated nodal officers, standard request formats, and channel for communication with other states, central agencies, and foreign jurisdictions. Equally important is the need for timely preservation requests and internationally accepted procedures for handling digital evidence from across jurisdiction. The filing of charge sheet is the beginning of the next stage of the criminal justice process. As we know, the quality of prosecution largely depends upon the quality of investigation. Before the police report is filed, it is important to ensure that all relevant documents are available. This includes forensic reports, medical reports, expert opinion, sanction orders, electronic evidence, and complete witness details. Deficiencies in any of these normally surface during the course of trial, resulting in supplementary reports, repeated adjournments, or avoidable delays. So, this stage requires close coordination between police and prosecution. Early legal scrutiny can help to identify the deficiencies. Simple measures such as pre-charge sheet filing checklists and trial readiness reviews can improve the quality of prosecution and reduce delay during trial. So here the objective should not merely be to file the charge sheet within time, but to ensure that the case is complete and ready for trial. Coordination during trial. Once the case reaches the court, coordination among all stakeholders become equally important. The court depends upon the police for execution of summons and warrants, production of accused persons, production of records and case property, and securing the attendance of witnesses. At the same time, prosecutors, forensic experts, medical officers, and prison authorities also have important responsibilities during the course of trial. Our experience shows that delays occur due to coordination issues, witnesses may not be served summons in time, expert witnesses may not be available on the date of hearing, records may not reach the court in time, or accused persons may not be produced as directed by the court. These delays result in adjournments even though the court is ready to proceed. Therefore, timely disposal of criminal cases requires the entire criminal justice system to function as an integrated process. The progress of a criminal trial depends not only on the completion of investigation but also on the timely issuance and execution of judicial processes. Summons, warrants and proclamations should move without avoidable delay and their execution should remain visible to all stakeholders. Similarly, supporting institutional measures such as proper verification of sureties, appropriate and timely action against fake bailers can improve the effectiveness of the criminal justice process. Misuse of bail process through fake bailers, stock witnesses, etc. can delay the proceedings and affect the administration of justice. Another important aspect is continuous coordination between the court, prosecution, and the investigate agency in this regard. Another area where coordination is critical is the implementation of the provisions of trial in absentia. The process begins with the timely issuance of warrants, proclamations, and other processes by the court. Therefore, the police are required to execute these processes promptly, trace the accused, and take necessary steps prescribed under the law. Where required, property may also have to be attached in accordance with the prescribed procedure. Throughout this process, there must be continuous exchange of information between police, prosecution, and the court. These proceedings should be supported by clearly defined workflows for the issuance and execution of warrants and proclamations, and digital monitoring of compliance should also be available. Only when every stakeholder performs his role in a coordinated and time-bound manner can the provision relating to the trial in absentia achieve their intended objective. Similarly, designated courts for high-volume cases like Arms Act, etc. can also be considered. Service of process is one of the most important links between investigation and trial. Even when investigation is complete and the court is ready to proceed, the case may not move forward unless the summons, warrants, and notices are served timely. Service of process often involves coordination across jurisdictions. A summons may have to be served through another police station, another district, or even in another state. So BNSS recognizes electronic modes of communication and e-summons application is in place. So manual summon processes may please be discouraged. Electronic transmission, digital acknowledgement, status tracking, automated reminders, and supervisory dashboards can make the execution of processes more efficient. Here the objective should be to enable the honorable courts to know the status of every process. This will reduce avoidable delays during trial. One of the biggest opportunities before us in implementing the provisions of BNSS is use of technology. This is not merely for digitizing records, but for digitizing the workflows. Today, technology platforms such as CCTNS, ICJS, eSakshya, eCourt, eFSL are already available. The next stage should be to use these platforms for seamless movement of requests, reports, approvals, and information between agencies. Instead of manual correspondence, every statutory request should move through a defined digital workflow. The receiving authority should be identified automatically. Acknowledgement should be automatic. Pending requests should remain visible. Reminders should be issued automatically, and the supervisory officer should be able to monitor the progress through their dashboards. Such systems can help to identify delays at an early stage and corrective action can be taken before the timelines are affected. Ultimately, technology should simplify coordination, reduce avoidable delays, and enable the stakeholders to work together. The coordination issues that we have discussed so far do not require major legislative changes. Most of them can be addressed through administrative reforms, standardization of procedures, and better use of technology. The first requirement is to identify every mandatory requirement of the BNSS and map the workflow associated with it. It should be made clear as to who initiates the request, who receives it, and who is competent to act, the timelines for response, and the manner in which the response is to be communicated back. Secondly, departmental manuals, standing orders, standard operating procedures, etc. should be reviewed and aligned with the requirements of the BNSS. Many of these procedures were framed under the earlier legal framework and may need to be updated to facilitate electronic communication, digital records, and time-bound compliance. Thirdly, departments should identify nodal officers for handling inter-agency requests and prescribe response timelines. Supervisory officers should have the ability to monitor pending requests and intervene whenever necessary. In short, every statutory interaction should have well-defined workflow and supported by technology across the departments. The BNSS has provided the legal framework for a faster and time-bound criminal justice system. Our experience over the last 2 years shows that the next phase of implementation is not about creating more laws. It's about ensuring that all institutions work together effectively. Going forward, we need to align our administrative procedures with the new legal framework. Departmental manuals, standing orders, and internal processes should support timely coordination instead of causing delays. Wherever possible, manual correspondence should be replaced by digital workflows. Early requests should be acknowledged, tracked, completed within prescribed time limits with clear accountability at every stage. Regular coordination meetings between police, prosecution, forensic laboratories, courts, and other government departments will also be essential to identify and resolve operational bottlenecks. If we can institutionalize these mechanisms, the timelines prescribed under the BNSS will become achievable in practice. Before I conclude, I would like to leave one thought with this august gathering. The success of the BNSS will not be judged by the number of legal provisions that we have created. It will be judged by how well the stakeholders work together to deliver justice timely to citizens. Thank you.
Thank you so much, Mr. Kanan, for your insightful words, detailing the areas of concern which we need to address with coordinated and concerted efforts for achieving the ultimate objective of timely justice. Thank you so much. I would now invite Mr. Subhash Chandra Sharma, the Director Administration of the Bihar Judicial Academy. He has been in the Bihar Judicial Service for the past 20 years and served on all key posts of Junior Division and Senior Division cadre. He joined the Bihar Judicial Academy this year, and I'm told that he is doing exemplary work. So I think we are prepared to get enriched by your knowledge and wide experience. Mr. Sharma.
Thank you, Ladyship. Honorable Chair and Honorable Co-Chair of this session, Honorable Judges of the Patna High Court, Honorable dignitaries on and off the dais, distinguished participants and stakeholders in the criminal justice system. I stand before you today not merely as a trial judge, but as one who occupies the final destination at district level in the long journey that a criminal trial undertakes. From the registration of a first information report to the pronouncement of judgment, I see every day the files that arrives in my court. I see the delays written to them. I see the opportunities for justice that were lost somewhere along the way. And I see, with the coming of the new criminal laws, the BNS, the BNSS, and BSA, a historic opportunity to rewrite this narrative. The question before us today is not whether the new laws are ambitious. They are. The question is whether we, as a collective criminal justice ecosystem, are prepared to meet the ambition through the robust interagency coordination. For let me be clear, no amount of legislative reforms can deliver speedy justice if the agencies responsible for implementing it continue to operate in silos. The Bharatiya Nagarik Suraksha Samhita 2023 has ushered in what can only be described as a paradigm shift. For the first time in our criminal procedural history, we have a comprehensive framework of mandatory timelines that bind every stakeholder, from the investigating officer to the trial court. Yesterday in technical session 2, this aspect has been dealt in detail regarding that mandatory timelines. At the outset, we must admit that there are coordination challenges amongst the stakeholders of the criminal justice system. Let us be honest with ourselves. As a trial court judge, I have seen too many cases where the investigation was impeccable, but the forensic report arrived late. I have seen cases where the forensic report was timely, but the prosecution was not ready. I have seen cases where everyone was ready, but the material exhibits were not formally placed on record. I have seen cases where the evidence was available, but its digital authenticity could not be established. Delay is rarely the fault of a single agency. It is almost always the product of a coordination failure. The new criminal laws recognize this fundamental truth. Section 193 of the BNSS now mandates that a police report must include the sequence of custody in case of electronic devices. This is not a mere procedural formality. It is a recognition that in the digital age, evidence moves across multiple hands, and every hand must know what the other is doing. Similarly, the mandate for forensic investigation in offences punishable with 7 years of imprisonment or more is a legislative acknowledgement that the police cannot do it alone. The forensic expert must be at the crime scene, must collect evidence properly, and must do so within a time frame that allows the investigation to proceed. This is where the technology becomes our greatest ally. The interoperable criminal justice system, ICJS, is not merely a software platform. It is a nervous system of the new criminal justice architecture. This technical bridge and ICS and digital integration was discussed in yesterday's session by Honorable Mr. Justice Joy Mallya Bagchi in detail. Under the ICJS framework, we now have a one data, one entry protocol that enables real-time data sharing among police through CCTNS, e-courts, e-prisons, e-prosecution, and e-forensics. This means that when an investigating officer uploads a charge sheet, the prosecution can access it immediately. When a forensic report is generated, the court can receive it digitally. When a summons is issued through e-summon, its service can be tracked electronically. Consider e-Saksh, the digital evidence collection and management application. The new laws mandate that in every case where an FIR is registered, digital evidence must be recorded and stored in the app according to procedure. Search and seizure operations must now be recorded through audio-video means and forwarded to the magistrate without delay. This is not about adding to the investigating officer's burden. It is about creating an unbreakable chain of custody that eliminate dispute about evidence tampering and dramatically reduces the time spent on evidentiary challenges in court. Nyaya Shruti, the video conferencing platform from trial courts, enable virtual hearing that ensure continuity of trials even when witnesses or accused persons cannot physically appear. Medlepar, that is medico-legal examination and post-mortem reporting, digitizes medico-legal processes, enhancing coordination between medical institutions and law enforcement agencies. These tools are not optional. They are the machinery through which the timelines of the new laws will be achieved. Let me share with you what effective interagency coordination looks like from the perspective of a trial court judge. First, coordination begins at the crime scene. When a forensic expert visits this scene along with the investigating officer, when both collect evidence together, when the audio-video recording is made and transmitted immediately, this is coordination that saves weeks, sometimes months of procedural time. Second, coordination continues through the investigation. Section 193(3) subclause 2 of the BNSS requires the police officer to inform the victim or informant of investigation progress within 90 days. This is not merely a victim rights provision, it is a coordination mechanism. An informed victim is a cooperative victim. A cooperative victim means fewer adjournments, fewer delays in witness examination, and a smoother trial. Third, the coordination is critical at the stage of charge framing. Honorable Mr. Justice N. Koteswar Singh sir was discussing this aspect in the inaugural address regarding that coordination at the time of framing of charge. The magistrate or the sessions court must frame charge within 60 days of the first hearing as per the mandate of the BNSS. This requires the police to have filed a complete charge sheet, the prosecution to have reviewed it, and the court to have all necessary documents. Any breakdown in coordination at this stage is a missing forensic report, an incomplete charge sheet, an unavailable witness list results in delay that the law no longer permits. Fourth, coordination determines the quality of trial. The BSA now recognizes electronic records as primary evidence. This means that the police, the forensic experts, and the prosecution must work together to ensure that the digital evidence is collected, preserved, and presented in a manner that meets the standards of the court. A single gap in this chain can render crucial evidence inadmissible and derail the entire prosecution. But we must also confront the challenges. As the India Justice Report 2025, which is a first of its kind national periodic reporting that ranks the capacity of the states to deliver justice, observed there is an average vacancy rate of 22% in police forces and the district judiciary. Many police stations, especially in remote areas, lack basic internet access and digital tools. Courtrooms are not yet uniformly equipped to handle digital submissions and virtual hearings. The government is now considering linking the performance appraisal of police officials to the timely completion of investigation. This is a welcome step, but it must be accompanied by capacity building, infrastructure development, and a genuine commitment to interagency coordination. The state government has already initiated extensive training programs for police, prosecutors, and judicial officers, and the present conference is also part of this exercise. But training alone is not enough. We need continuous hand-holding, issue resolution mechanism, and real-time feedback systems that allow functionaries to communicate the challenges they face. Distinguished participants, the new criminal laws have given us the framework. Technology has given us the tool. What we need now is the will to coordinate. I urge the police to embrace transparency, to use e-Saksh not as a burden but as a shield against allegation of tampering. I urge forensic experts to understand that their reports are not academic exercises but the building blocks of justice. I urge prosecutors to prepare their cases in tandem with the investigation, not after it. I urge my fellow judicial officers to use technology proactively, to issue e-summons, to conduct virtual hearing where appropriate, and to enforce the timelines of the BNSS with firmness and fairness. And I urge all of us to remember that behind every file, behind every charge sheet, behind every judgment, there is a victim waiting for justice and an accused entitled to a fair and speedy trial. The new law promises justice within 3 years of the registration of the FIR, but promise will remain unfulfilled if we do not coordinate. It will remain a legislative aspiration if we continue to work in silos. It will remain a distant dream if we do not embrace the spirit of collaboration and these laws demand. Let me conclude with a thought that I carry with me every day on the bench. A trial court is not an isolated island. It is the meeting point of all the streams of the criminal justice system: the investigation, the forensic analysis, the prosecution, the defense. If any of these streams is polluted with delay, the final product, justice, is polluted too. The new criminal laws have given us a historic opportunity to cleanse these streams. They have given us the mandate of timeliness, the tools of technology and framework of coordination. It is now up to us, each one of us, in our respective roles, to rise to this occasion. Justice delayed is justice denied, but justice delivered through coordination is a justice fulfilled. Thank you.
Thank you very much, Mr. Subhash Chandra Sharma, for your enlightening words. You stated quite vividly about the various stages of investigation and trial where a robust coordination mechanism has its extreme significance, and also the challenges which we have to face and eventually overcome. So now, I now invite my co-chair, Mr. Justice Ajit Kumar, for giving his conclusion speech on today's topic.
All the esteemed judges, respected chair, resource persons, all the dignitaries, judicial officers, audiences, and the persons who have joined virtually. Justice delayed is justice denied. It's not merely a legal maxim, but is a lived reality for millions of litigants, victims, and under trials in our system. The journey from FIR to final judgment is a chain involving the police, forensic labs, prosecution, judiciary, and correctional services. A delay at any single link breaks the entire chain of justice. As officers of this very judicial system, my focus today is on the judicial dimension of this coordination, how the courts, through courts management and supervisory powers, can complement rather than complicate the work of investigation and prosecuting agency. This is what has been addressed by both the resource persons. In Satyajit Banerjee versus State of West Bengal, reported in 2005, 1 SSC 115, the Honorable Apex Court has distinguished the right to a speedy trial from right to a fair trial under Article 21, holding that delay alone, unlike denial for a fair trial, does not necessarily prejudice the accused. The right to a speedy trial is relative, assessed case by case, and mere lapse of time cannot justify discharge of prosecution. Crucially, this court held this right does not preclude the right of public justice. Speed must never come at the cost of a fair, thorough prosecution. The goal is not expedition for its own sake, but a shared constitutional duty binding every agency to be both swift and just. Judicial restraint in fixing timelines and balancing speedy trials with systematic equity is the core issue that needs to be addressed. Our constitutional courts have cautioned against routinely fixing rigid timelines for disposal of cases in district and trial courts. Often while granting bail, a time frame is fixed for concluding trials on the ground that the accused has suffered prolonged incarceration, overlooking that the same court may have other under trial languishing even longer. Without any such directions, coordination cannot rest on courts' imposed deadlines in isolated cases. It must address delays sympathetically, and coordination, which is the core for bringing the trial to a conclusion, that needs to be addressed. This is also raises a question of equity. Not every litigant can approach a constitutional court. Granting out-of-turn priority liberally risks letting those who can reach higher courts leap ahead, while others wait patiently in queue. Such decisions are best left to the trial courts at many times, but the inter-coordination that has to be taken to a logical conclusion, which the resource persons have just now addressed, that right from the collection of materials during course of investigation, inquiry being concluded, electronic records being fetched, and ultimately with the interagencies coordination, the trial being concluded, that has to be brought to a logical conclusion very fairly. And as Dr. Martin Luther King Jr. said, injustice anywhere is a threat to justice everywhere. Let this truth guide our work every single day. And with these words, I conclude, and I thank you.
We are extremely thankful to Justice Ajit Kumar for your valuable words and the focused speech. I am confident that the recommendations emerging from today's deliberations will assist in strengthening the interagency coordination and facilitate the effective implementation of the new criminal laws. More importantly, they will contribute towards building a criminal justice system that is efficient in its processes, fair in its approach, and worthy of the confidence that citizens repose in our institutions. With these observations, I declare this technical session concluded. Thank you all for your valuable participation.
There is one question. I want to put one question from...
Sorry, somebody had a question, please.
This question is from P. Kanan IPS. Because in Bihar, it is our experience in series of cases, the police is in habit of filing multiple charge sheets in one case. Is there any provision that multiple filing charge sheet is necessary, particularly when material has already come, but when police arrested the accused, then only charge sheet filed? Whether it is also necessary in law that for filing the charge sheet, arrest of the accused is necessary? Is there any law framed by the state government, any rule, any form, any SOP, any direction by the officials that until and unless you will not arrest the accused, don't file charge sheet? Why? Because this resulted into the many different trial in one case. My experience is I am inspecting judge in 3-4 districts, and when I sit before the ADJs, I have gone through that in one criminal case, there are 7 trials are going on, 8 trials are going on. So I just want to know, being the IG provisions, particularly I want to know because participants, the prosecutors are there, the senior officers, police is there, the judicial officers are there. Therefore, I just want to know that whether it is the direction of the police that arrest first, then file charge sheet. Please explain it.
Sir, thanks, sir.
And what is the provisions of filing supplementary charge sheet in this regard? Any SOP? Then please explain.
Sir, even Bihar Police Manual, sir, makes it clear that a case cannot remain pending with the IO for the purpose of making arrests. The BNS doesn't mandate. BNSS say that there is no need for making arrest when the investigation is complete. So the position of law is very clear, sir. The position of police manual is also very clear. But unfortunately, it is being practiced at the district level. We have actually issued multiple orders already, sir. Unnecessary delay should be avoided. But during supervision, sir, officers normally write that you make arrest or you go for processes. This actually causes delay. Otherwise, sir, there is no provision in the manual or in the BNSS, sir, to...
So, is there any record with you that in cases, in how many cases you are, means Bihar police is in habit of filing the multiple charge sheets?
Sir.
Please take record of that, please issue instructions so that unnecessary delay, if material comes, then you file charge sheet.
Sir, sure, sir. We will
Whether
ensure.
arrest, no arrest, because there are two things on which to be taken care of. Let us suppose you have not filed charge sheet, you have exhausted every process for making absconding, and then you do something, and let us suppose you file the charge sheet, cognizance shall be taken. The same process you have to be taken when through the process of the court absconding, and you know that in the BNSS,
Yes.
the clear-cut direction is that trial in absentia can go.
Sir.
So you please take care of that.
Yes, sir.
Bihar judiciary is loaded in such type of cases because multiple examination of witnesses, multiple conning, multiple processes are started. So I hope so that you will take care of that, and such mistakes which is going on in future must not be taken place in Bihar.
Sure, sir.
My question will be...
I do have a question.
Another thing, Mr. Kanan sir, another thing is that, another thing is that when multiple charge sheets are filed and it is being tried by different courts on the same incident, some court may find the accused guilty and convict and sentence him, and some courts may find him acquitted. So in that case, there is number one, multiplicity of proceeding and difference of opinion in respect of different cases. In respect of one case, same and single case where two views from two judges are coming, that is absolutely dangerous. When it comes to the High Court, the defense is taking plea that when in one case order of acquittal has been passed, why in my case on the same footing order of conviction is to be sustained. That is the main problem. Sitting in appeal, we are regularly experiencing this.
So, yes, sir, we understand this problem, sir. The manual is very clear. The police manual is being reworked, sir. We will get this provision specifically incorporated, sir. We will issue administrative orders also, sir.
I have a specific question in respect to trial in absentia, because many democratic countries has refused this, so there will be a human right issues related to it. So do you have any SOP related to trial in absentia?
No, sir. For trial in absentia, we have not issued any SOP so far because the matter has yet to be, from judiciary side, we need support actually to understand the issues. Because
many European countries have refused this because it violates human rights. So there must be some SOP regarding this.
So far we have not issued, sir. We will issue. So.
Thank you.
I too have a question. Mr. Kanan,
Sir.
During investigation, why do police need warrant from the court in a cognizable, non-bailable offence?
Sir, exactly, sir, for the reason of making arrests. So, it's not required.
Why you can make the arrest without any warrant from the court? It's a cognizable offence, it's non-bailable. So what's the problem?
This has been a practice, sir. It doesn't derive any authority from law or from the police manual. It is being practiced for quite a long time, and we are trying to overcome this process. Now, the BNSS has made very specific provisions, sir. We keep insisting our officers to file charge sheets once the evidence or complete investigation is complete. We will again reiterate them, sir.
No, but I want to flag this matter because the purpose, you are not saying in clear words but the purpose only is that you need a proclamation, whether for to declare him an offender for attachment. So, because unless the court orders gives you warrant, so you cannot seek that. But please be clear. When an offence is cognizable, it's non-bailable, it's your duty. Court cannot come to your aid for in arresting or producing the accused. So, when an offence is cognizable, it's non-bailable, you go and arrest during investigation. You are yourself saying that there is no bar in filing charge sheet without making the arrest. So why?
Sir, again, it's a practice, sir. Again, it is a practice, sir. Now, in police, there is an understanding that by ensuring the arrest of the accused or by ensuring they are surrendered before the honorable court, we are facilitating the job of court. That's all. So that's the only purpose behind this practice. Otherwise, sir, it doesn't have any legal basis. Yes. Sir.
So better stick to your policy.
Sure, sir.
Yes.
Sir, we will get an order issued.
Thank you.
Sir, thanks.
Mr. Kanan, there is
sir, please, sir.
one question from this side. See, one thing which we are always experiencing, suppose you found one person murdered someone, he shot at someone with a pistol and the victim died. You are registering a case under section 302 IPC and then you are registering another case under section 27 of the Arms Act. So, you are registering two different FIRs for the same and one transaction of the offence.
So,
in one matter, I had an opportunity to interact with one of the superintendent of police. So, he agreed with the views that yes, two FIRs should not be lost. But this is being repeatedly done.
so,
No.
so.
Why is that you are registering two FIRs?
Sir, seems, yes, sir, again it's in practice, sir, 27 Arms Act need not be invoked because when the offence of murder is complete, the weapon used for committing the offence need not be, sir, invoked in the FIR. Sir, we will again, sir, appreciate all the investigating officers to follow proper practices, sir.
Thank you.
Sir.
We have one more question from the participants.
Can somebody please give a mic to the participant who wants to ask a question? हम तक तो आ रही है, आप थोड़ा और खड़े होकर जोर से बोलें.
Learned participant, you are being given a microphone, please.
हेलो. एक प्रोविजन है क्लियर कट दिया हुआ आईपीसी में भी था और बीएनएसएस में भी दिया, बीएनएस में भी दिया गया है 174A, जिसमें कि प्रोविजन है कि 82 अगर प्रोसेस इशू हो गया और उसका पुलिस कंप्लाइंस कर करके रिपोर्ट अगर ऑनरेबल कोर्ट को दे देते हैं तो लर्नेड कोर्ट उसके खिलाफ प्रोविजन है कि उसके अलग से केस फाइल होंगे, जो कि नया BNSS 209 में भी दिया गया. पहला, ये अभी शुरुआत नहीं हो रहा है, कहीं हमने नहीं देखा कि 209 दिल्ली वगैरह में कुछ केसेस हुए हैं, लेकिन इसमें केस नहीं हो रहा है. चूँकि अपीयरेंस के केस अगर देखें तो 18 लाख से प्लस केसेस ट्रायल में भी पेंडिंग है ऑनरेबल, और अपीयरेंस पर 7 लाख लगभग टोटल केस जो बिहार में मजिस्ट्रियल ट्रायल के लिए है. और दूसरा, जनवरी से लेके मई तक 7113 विटनेस वापस हुए, जबकि ऑनरेबल हाई कोर्ट का एक सर्कुलर है मीर उस्मान वर्सेस सीबीआई वाले केसेस में सर्कुलर भी इशू किया गया कि अगर नहीं उस दिन, चूंकि लोड ज़्यादा है कोर्ट पर, इतना नहीं है कि सबको हम करा पाएँ, इतने ज़्यादा केसेस ट्रायल में हैं, तो उसके लिए ऑनरेबल कोर्ट के द्वारा दिया गया है कि 346 सब क्लॉज 2 के तहत जो प्रोविज़न है कि डे टू डे जब तक उसका डिस्पोजल नहीं हो जाए, डे टू डे उसका ट्रायल गवाह कराया जाए जब तक कि अपीयर विटनेस ना हो। लेकिन मैक्सिमम कोर्ट में, बहुत सारे लर्नेड कोर्ट के द्वारा डे टू डे कराया जा रहा है, लेकिन मैक्सिमम केस में ये नहीं हो रहा है। तो वो जो 174A और 209 का है, ये इनिशिएट अगर किया जाए तो अभी हमको लगता है कि ये प्रोविज़न है। दूसरा, हमारे एक ऑनरेबल ने कहा कि अभी कि नॉन कॉग्निजेबल केसेस में पुलिस को राइट है, अगर वैसे केसेस में एक्चुअली डायरी में नहीं वो मेंशन करता है कि हाँ ये भाग के कलकत्ता चला गया, कलकत्ता जाएंगे तो वारंट तो चाहिए, तो वो आयोग की गलती के कारण उसमें मेंशन करके आप डे टू डे डायरी में नहीं मेंशन करते हैं, इसलिए लर्नेड कोर्ट कहते हैं कि आपको कॉग्निजेबल ऑफेंस है तो आप क्यों नहीं जा करके खुद अरेस्ट करते हो। ये पुलिस के तरफ से प्रॉब्लम आता है, इस कारण से ये होता है। तो ये मेरा यही था कि 209 और 174A को अगर स्टार्ट किया जाए हमारे यहाँ भी, तो पेंडेंसी बहुत ज़्यादा कम हो सकती है, और एक्यूज जब अपीयर होता है तभी वकील साहब आते हैं, नहीं तब तो डेट पर डेट वकील साहब लेते रहते हैं। एक्यूज आएगा तो वो धक्का दे करके ले जाएगा वकील साहब को कि चलो मेरा केस आ गया। थैंक यू।
I think this is just his opinion. I don't regret this.
I think we have taken it as your view, and we know that Section 174A is in place. Section 174A of the IPC, which is probably now 209 of the BNS, is in place. So maybe there instances I have not been there of, although it's a non-bailable offence, non-bailable and cognizable offence. So maybe there are instances have not been there, but then the provision is in place, and I think whenever required, that call will be taken. Okay. Thank you so much.
Thank you, honorable judges and respected participants and speakers for this enriching interaction. We shall now move forward to the next technical session, for which I would request the organizers to get the dais ready. Meanwhile, I'll request your kind attention to a short video of BIPARD.
Bihar, cradle of governance legends transforming anew through BIPARD. A 27-acre residential campus, beacon of public leadership and empowerment. From humble origins, work accelerated in recent years, and within months, BIPARD emerged as a modern hub of purpose. Training 1,700 officers simultaneously through unparalleled residential programs. Every day at BIPARD unfolds as a microcosm of the life officers are preparing to lead. A life dedicated to service, discipline, and impact. At BIPARD, dawn births discipline with days unfolding in 6 engaging lectures. Evening features yoga, volleyball, football, and swimming. A highlight of the Institute's training is the immersion trip. Officers traverse diverse states, uncovering best practices and innovative strategies. Each group explores at least 4 states, dedicating around 15% of their course to this transformative experience. The benefits are profound. Visiting states like Kerala to understand participatory governance and Gujarat for rural infrastructure, which are known for their successful governance models. Visit to other esteemed institutions offers them a panoramic view of the nation's governance, immersing them in country-wide perspectives on critical issues and transformative practices. Immersive visits to rural and tribal areas ground officers in the realities of grassroots challenges. These journeys culminate in detailed reports, blending observation with insight, essential for their evaluation. BIPARD stands as a crucible for courses of national significance, shaping officers at every stage of their careers. Here, hierarchy blurs as government servants, peons, drivers, clerks, and IAS officers converge for training. From nurturing life through tree plantation drives to harnessing the power of cloud computing and AI, Bihar's Gen X Lab stands as a beacon of innovation. Inspired by Niti Aayog's AI Lab, this visionary initiative on BIPARD's campus has become a hallmark of cutting-edge decision-making within the prestigious Knowledge Corridor, blending the wisdom of tradition with the promise of technology. To enrich training, BIPARD has MOUs with 27 institutions, including a tripartite pact with the Capacity Building Commission. The Karma Yogi Bharat Lab, nestled within BIPARD, embodies a promise of boundless learning. Linked to the IGOT Karma Yogi platform, it promises to empower civil service officials with the freedom to learn anytime, anywhere, on any device, nurturing their competencies and shaping them into the architects of tomorrow's governance. A thriving society blossoms when governance is rooted in visionary policy and administration. At BIPARD, future public servants are shaped with unwavering competence, integrity, and a commitment to rural development and good governance, preparing them to write the future with the golden ink of inspired leadership.
Participants, kindly settle down. We'll begin with technical session 4. Respected dignitaries and participants, technology has emerged as a transformative force in the administration of criminal justice. Digital evidence management, real-time case tracking, electronic communication with witnesses and citizens, and the integration of technological tools are indispensable to the successful implementation of the new criminal laws. This session is dedicated to exploring these technological initiatives and their practical implementation. For this session, may I respectfully invite Honorable Mr. Justice Alok Kumar Sinha, Judge, Patna High Court, to kindly preside over this session as the chair. May I respectfully invite Honorable Mr. Justice Saurendra Pandey, Judge, Patna High Court, to kindly grace the dais as the co-chair. May I respectfully invite Shri Ranjan Kumar, Joint Director, IT, National Informatics Center, to kindly grace the dais. May I also respectfully invite Shri Ranjit Shankar Prasad, In Charge Law Officer, Home Department, to kindly grace the dais. We shall now begin with the felicitation ceremony of the dignitaries on the dais. I request Shri Bharat Bhushan Bhasin, Director, Bihar Judicial Academy, to kindly felicitate Honorable Mr. Justice Alok Kumar Sinha, Judge, Patna High Court. I now request Sri Subhash Chandra Sharma, Director Administration, Bihar Judicial Academy, to felicitate Honorable Mr. Justice Saurendra Pandey, Judge, Patna High Court, with a planter and memento. I request Shri Nishikant Thakur, Additional Director, Bihar Judicial Academy, to kindly felicitate Shri Ranjan Kumar, Joint Director, IT, National Informatics Center, with a planter and memento. I request Shri Mukesh Kumar, Deputy Director, Bihar Judicial Academy, to felicitate Shri Ranjit Shankar Prasad, In Charge Law Officer, Home Department, with a planter and memento. The floor is now handed over to the respected Chair, Honorable Mr. Justice Alok Kumar Sinha, Judge, Patna High Court, to kindly moderate this fourth technical session.
Honorable Mr. Justice Rajiv Ranjan Prasad, JD2, and Chairman of Bihar Judicial Academy, all my esteemed brothers and sisters, Mr. B. Rajendra, Director General of BIPARD, all the participants, distinguished participants who have come here, my resource persons, a very good morning to all of you. This session is centered on the subject that is redefining the manner in which justice is administered in our country. The justice delivery system is undergoing a significant transformation. The traditional methods of investigation, evidence collection, court management, and service of judicial processes are steadily giving way to technology-driven systems that are more efficient, transparent, reliable, and citizen-centric. The enactment of Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Sakshya Adhiniyam marks not merely a change in statutory law, but also a conscious shift towards a modern criminal justice system where technology is integrated into every stage of criminal process. Digital evidence, electronic communication, online case management, and technology-enabled coordination among various criminal justice institutions are no longer matters of the future. They have become an essential part of the present-day functioning. It is in this backdrop that today's training assumes great significance. During the course of this session, we shall be familiarized with 4 important digital initiatives that are expected to play a transformative role in strengthening criminal justice administration. The first among them is e-Sakshya, a comprehensive platform designed for the scientific collection, preservation, documentation, and presentation of electronic evidence. In an age where mobile phones, computers, CCTV footage, social media communications, and digital records frequently constitute crucial evidence, ensuring the authenticity, integrity, and chain of custody of such material has become indispensable. e-Sakshya seeks to provide a secure and legally compliant mechanism for handling electronic evidence in accordance with requirement of Bharatiya Sakshya Adhiniyam. We shall also discuss the case information system, which has become the backbone of digital court administration. By facilitating electronic case management, real-time monitoring of judicial proceedings, generation of reports, and seamless access to case information, CIS has significantly enhanced efficiency and transparency in court functioning. Effective utilization of this platform enables better judicial administration and contributes towards timely disposal of cases. Another important initiative is e-Summons, which seeks to modernize one of the most fundamental stages of criminal proceedings, the service of summons and notices. The delays in service of processes have often resulted in unnecessary adjournments and prolonged litigation. Through electronic generation, transmission, tracking, and acknowledgement of summons, this initiative aims to make the process faster, more reliable, and fully compliant with the statutory framework under the new criminal laws. We shall also have the opportunity to understand Nyaya Shruti, a progressive initiative intended to improve communication with victims and witnesses. Timely dissemination of information regarding hearings, case progress, and other developments can significantly reduce inconvenience to stakeholders while promoting greater participation, transparency, and confidence in the justice delivery process. Such citizen-centric innovations reflect the larger objective of making the judicial system more accessible and responsive. Each of these initiatives represents far more than technological advancement. They embody a shift towards a judicial system that is efficient, without compromising fairness, and modern while remaining faithful to the principles of due process. However, while these technological initiatives are undoubtedly remarkable, we must always remember that technology is only an enabler. It can assist us in performing our duties more efficiently, but it cannot replace judicial wisdom, fairness, or adherence to the rule of law. The effectiveness of these digital platforms ultimately depends upon our willingness to understand them, adopt them responsibly, and utilize them in a manner consistent with legal safeguards and constitutional values. I therefore encourage each one of you to actively participate in today's program. Please do not hesitate to raise practical questions, seek clarifications, and share experiences from your respective jurisdictions. Such interactions enrich the learning process and contribute to the successful implementation of these initiatives across the justice delivery system. We are privileged to have with us 2 distinguished resource persons whose knowledge and practical experience make them exceptionally well suited to guide us through today's technical sessions. Our first resource person is Mr. Ranjan Kumar, Scientist D and Joint Director IT at the National Informatics Center, Government of India. Mr. Kumar is a graduate in Computer Science and Engineering from NIT Jamshedpur and has professional experience with Tata Consultancy Services before joining the National Informatics Center. Since 2019, he has been closely associated with the interoperable criminal justice system, project where he has led important initiatives including e-prosecution and e-summons. He has made significant contributions to the design and development of digital justice platforms such as e-Sakshi, e-summons and Nyaya Shruti, and has conducted extensive training programs and stakeholder consultations across several states and union territories for the implementation of the new criminal laws. His experience in leveraging technology for judicial reforms makes him one of the foremost experts in this field. Our second person, Mr. Ranjit Shankar Prasad, who is presently serving as in charge of Legal Cell Home Department, Government of Bihar. He has been actively involved in legislative drafting, policy formulation, and legal advisory concerning criminal justice administration. Mr. Prasad has made substantial contribution towards the implementation of the new criminal laws by drafting several important subordinate legislations. For the state, including the Bihar e-Sakshi rules, Bihar electronic summons rules, Bihar community service rules, and the Bihar custody and property rules, besides contributing to various other legislative and policy initiatives. He has also prepared numerous policy papers, standard operating procedures, training modules, and reference materials on electronic evidence, cyber law, digital forensic, and new criminal laws. He is the co-author of the book Navigating the Digital Evidentiary Labyrinth, published by All India Reporter, and is widely recognized for his work in the field of technology, enabled criminal justice reforms. I am confident that both our distinguished resource persons will provide valuable insights not only into the technical functioning of these platforms, but also the legal principles and procedural safeguards governing their implementation. Their practical experience will undoubtedly make today's deliberations both informative and enriching. As stakeholders in the administration of justice, we share a collective responsibility to ensure that these technological innovations are translated into meaningful improvements in the quality, efficiency, and accessibility of justice. By embracing these reforms with an open mind and a commitment to continuous learning, we can contribute to building a justice delivery system that is modern, transparent, accountable, and truly responsive to the needs of the society. With these words, I once again extend a warm welcome to all of you. I express my sincere appreciation to our distinguished resource persons for their valuable time and efforts. I hope each one of us leaves today's session with enhanced knowledge, renewed confidence, and practical insights, and will strengthen our collective endeavor to deliver timely and effective justice. Thank you. Now, I'll request our first resource person, Mr. Ranjan Kumar, to come and share his views on today's topic of the technical session. Mr. Ranjan Kumar.
Very good morning to Honorable Chair, Co-Chair, Honorable Judges, and respected dignitaries, esteemed officer from Prosecution and Police Department. As we have been talking about the introduction of new criminal law, which has been introduced in 2024 and came into effect from the 1st July. So with regard to that, lot of series of initiatives have been taken how to transform those provisions into electronic form in terms of design and development of the softwares. Now the designing of the software from the aspects where legal sanctity of each and every operations are well maintained, and ultimately it gives timely information pertaining to whatever domain it is interacting with. So we have heard from a lot of honorable speakers that justice delayed is justice denied. So the efforts are basically to reduce those time gaps and also provide all the informations which are available in wherever available in electronic mode to a particular place, so that they should not have any manual intervention in reaching out to the information. So we will be directly diving into the software modules which are designed on those lines. So first we will see all the major initiatives that has been taken with the introduction of BNS, BNSS and BSA. So first is the eSaksh platform, and I believe that Bihar state has started eSaksh, and they have generated lot of Saksh, and I think all the police officers are already registered on ICJS, which is Interoperable Criminal Justice System. Interoperable means that system should not work only in the silos, but they should definitely provide data to the next path, so that only the new and augmented data should be collected at the next phase. Be it start from the police, then if required goes to the prosecution, forensic, then court, and then prison. So eSaksh is a digital platform which creates a transparent, efficient ecosystem for capturing, managing primary evidences. So we must understand what is primary digital evidence, because evidence is primary as long as it is always retrieved from the source. Okay? If there is any intervention in between the two things, let's say the source and wherever it is getting retrieved, there should not be any processing, any intervention of manual or any bridge software, anything. It should always be a direct retrieval of the already stored information that is on the immutable system. So again, a term immutable system is the system where anything is written, anything is captured, anything is hash valued, that will not change during transmission, during its evaluation, and its retrieval on the platform in the viewable form. So this way we maintain its complete data integrity. Now about the system, I think if it is prevalent and it is being used, then it is digitizing the collection of the evidence. It is backed up by the secure storage and access mechanism. There is a seamless case linking facilities for all of the IOs who are working on the case. So wherever Saksh are created, they are responsible and the authorized users to link it. Real-time data availability. So once Saksh is captured and uploaded and linked with the case, it can be retrieved many times and during the proceedings as well, during even from the judge's dashboard. It gives the complete transparency and accountability. So all the information, meta information, like when it is captured, by whom it has been captured, what was the latitude, longitude, all those are well visible whenever it is presented. And the very important, it is integrated with ICJS. So Saksh system alone has no significance. It is just like you are capturing some videos and photographs on your mobile. But until it gets legal sign-in and updation and linking with the FIR, it has no meaning. It's absolutely waste of time and efforts. So please do not keep things pending for upload and linking. It's a mandate that electronic evidences, when stored into the primary sources, can be presented in the court. Now, little technical here, the architecture of eSaksh. So eSAKS primarily works on the mobile application. Why? Because we cannot have web portal working at all the places in the fields. Mobile is now into every iOS, and the Saksh official who is going in the field or the crime scene, they can carry it. All the authentication related mechanism is done by ICJS engine here. So you understand ICJS project started off in 2019, and with that we have onboarded all the police officials so that the basic authentication mechanism will always be there. Subsequent addition of software will keep on coming. So authentication and authorization is done by ICJS engine. Then there is a creation of Saksh packet. So what is Saksh packet? Saksh packet is basically, it is a encrypted bits which is recorded, and whenever you are recording, in the front you are seeing the video images or the clips, but in the background it's the bytes which is getting hashed, which is getting encrypted, and further it is assigned with a unique SID. So the packet's identifier is the SID. So why we call it a packet? Because we have to secure the chunks. Okay, so it's whenever a Saksh is recorded, it is divided into defined chunks. Right now it is 4 minutes for the video, and the image it is the entire file, but that is configurable. So understand, it should not be like a very lengthy packet, because that will create a lot of time while doing the pre-processing which we do for security. So that is in the chunks. This is the definition, means the packet. FIR linkage is the post process. Once your SIDs are, once your Saksh, in the particular Saksh there can be multiple images, multiple videos. Once those are created, they are ready for linking with the FIR. Now what is Saksh locker on the right hand side? So why we can guarantee that whatever is stored there will not be altered and will not be tampered. It is tampered proof. So one of the example is like DigiLocker, if you use, where you can store your academic files, driving licenses, other things. So why we do that? Because it guarantees somewhere that these are your files and that cannot be altered during transmission or even after storage. So that becomes immutable. So no another write can be performed on the same location. Now, how to access? After your Saksh is already stored at a secure place, how will you access it? And secondly, this directly goes into the cloud. So it's not state specific, district specific, or any police station specific, but all Saksh has a defined location in the cloud. Okay, so we may never tell you that from where it is coming, but it is always coming from a defined set of software, set of hardware, where the virtualization has been created. Saksh portal are the portals from which you can see how many Saksh has been taken, which police stations, which persons are most actively performing the collection of digital evidences. All those trackings are done on eSaksh portal. Now, the access to the court. For access to the court, right now we have taken some of the user list, and on that list we are directly giving eSaksh portals access, but the exact integration will be done with the CIS, in which we have already done the POC and it has been presented to E-Committee of Supreme Court. Now they are planning to release a patch which will be suitable, where the Saksh will directly be visible on all judges' dashboard itself. Okay, so that thing is in last stage. So right now we have received some of the user list from the Bihar in order to create users for Saksh view. Already some of the key features which we have discussed, like uniqueness of the Saksh ID. It captures geolocation, timestamp recording, and whenever your Saksh is recorded, it disables all the configuration for location changes, time alteration, and it works in DND mode. So suppose any calls or any messages pops up on the screen, then there may be chances that it may go into pause state. So in order to avoid that, it works on DND enabled state, and it gives you a pop-up so that you can enable it. Now if you want to see the hash value generation and how it looks on 63.4c Part A certificate issued in the subsequent slide. Key stakeholders. So right now we have covered all the investigating agencies. That includes other central agencies also. They have demanded for it, e-Saksh, other than the police. Courts, obviously, whenever there is a proceeding going on, Saksh has to be viewed. Prosecution. Now the committee has approved the view of all the Saksh captured in a case to be viewed by the prosecutor. Because whenever there is a scrutiny of a draft charge sheet by the prosecution department, Saksh has to be there so that they can see and give them the right advice or the right observation. Now the other stakeholders are accused, witness, victim, for which a digital platform is on way. So we have already designed some of the application on which the accused, witness and victim, these are a part of like citizen-centric approach, in which they can also see that these Saksh were taken at the time when the field officer was present, and they have equal rights to say it. But this will be given through an access matrix. So whether the approval of the judge is required or not, so that has to be seen. So how it works? So first we will see a video regarding authentication of Saksh app. So here you can see a screen which asks for 6-digit MPIN. So this is one of the first security layer, so that app cannot be opened by any external app, and it requires compulsory MPIN setting. Then it will ask for your mobile number. This mobile number is registered with ICJS system with appropriate role. Okay. So anyone cannot just start doing the e-Saksh, but their role has to be there, and that is governed by district level administration like SP, SSP on the ICJS platform. Now it asks for SSO login, single sign-on login, so that whatever you capture can be synced with the DigiLocker. It is all two-factored authentication. The second factor is background, where we check the user mobile number matched with the exact roles. Once you are successfully logged in, you are presented with following options: creating the new Saksh, pending to upload, mini statement, pending to remove from device, and pending to link with FIR. These are also available on e-Saksh portal. Okay. Now we will go into the first option of creating new Saksh. So how new Saksh is created? So already there are the sections, BNSS sections, in which Saksh has to be recorded. Suppose we have selected scene of crime. Now if about the incidents some information is to be given, this is the placeholder. At this point of the time, IO or the person who is capturing the Saksh, he doesn't know about what FIR to map with, because this is just the scene of the crime and nothing has come into the digital. This is the first thing which is going on. That is why we have mentioned without FIR. Now suppose this is the video which is getting recorded on through Saksh mobile app. Okay, it will not allow any other app to take the photographs or upload a already stored video. At this point you can see the probable location, that is Greater Noida, and its timing, start time, enter time, end time, The next is capturing of witness or image. So the timer also works on the photograph along with the geolocation. Now witness detail is, if available, it has to be mentioned here. So these are the dummy data, okay, for the demo purpose. It again asks you want to add more witness, it can ask. After that, the person who has recorded this saksh, so that person will take a selfie. Here we have avoided for the reason for identity issues. Now suppose this person has recorded all these saksh. Now how it views and where it appears. Okay, so the next point is pending to upload. So at this point, actually I wanted to pause. I could not see. Yes, at this point of the time, SID is visible, opening time, closing time is visible. Can we pause it? Pause कर सकते हैं. Yes. Okay, fine. I can demonstrate from here. Okay. Okay, now it's not like stopping there. But what I wanted to show, it shows all the recorded saksh which are yet to be uploaded. So until it is on your handheld device, it has again no value. Okay, and it appears as a red dot in the category of videos and the images. So let's see. The moment it starts uploading, the green tick will allow and let the IOs or the creator to understand that yes, this saksh has been updated or uploaded onto the cloud environment. Fine. Now we'll go to the next step, in which we can see about the mini statement regarding this saksh. So what happens if this saksh is associated with some of the, it may be associated with 2 FIR as well, but let's say it is associated with 1 FIR. So what is the current status in that FIR? That comes through the mini statement. Okay, so that facility is also there on mobile app. Now linking of saksh with FIR. So how to link those saksh with FIR? The video is not playing. Video is not playing. In this So how to link saksh with FIR? So these saksh will come with the option to link with the FIR. It allows the user to select the appropriate police station along with the district and which FIR number, which year this saksh belongs to. Okay. Now the declaration that they have already seen that FIR carefully and the saksh has been linked with that. After the saksh is linked with FIR, now you are very sure that saksh has already reached to its place, and now you can delete the existing file with the delete saksh option. So now we have implemented on all the states the eSaksh platform, but there are some BNSS sections which classify the evidences as primary, that is section 57 of BNS, electronic records as primary evidence, and section 61 declares that they have same value as physical document. Section 530 of BNSS enables use of electronic communication, audio, video, electronic means for issuance and service of summon warrants, which we will see next. New law also defines the audio-visual electronic means to include use of any communication device for the purpose of video conferencing, which we will see in Nyaya Shruti. So now we will go to the next module, and whatever questions we will take after the completion of slide. Can you present it here? The main screen. Yes. So we'll go to the Nyaya Shruti platform. This is the second initiative in which the audio-video concept of recording is available. So it is again a digital platform, and it is for the to facilitate the virtual court appearances through video conferencing facilities. It enables not only the court and particular IOs, but it can go to various domains for linking. So the meeting links can be virtually sent to accused, witness, police officers, prosecutor, forensic experts. And they do not have to log into the multiple systems, but they have to log into their daily software on which they are working. So the integration will come into picture with the Nyaya Shruti, in which we have already achieved in FSL, forensic labs, prison systems, and police system. So now in the court system, the court is the initiator of the Nyaya Shruti, which we will see in the demonstration. So these are all the legal sections on which the hearing and appearances are made legal through video conferencing. Video conferencing, section 154, 355, person may appear via video conferencing even if accused is absent, accused in custody, discharge, judgment, presence. So these all slides will be available, which can be referred. So I'm more interested into showcasing the demo part. These are the charges, evidences, and examinations. Now there are some stakeholders which are important to be understood. I think court oversees, maintains decorum and ensures fairness and deliver judicial decisions. So what this video conferencing will enable all the judges to initiate the VCs. There has to be a court master who will be assisting the judges to schedule, manage digital record, and assist in proceeding and making the people appear one by one in a particular sequence. Okay, through a video which will play, I will explain it. Then advocates can also be a party, witnesses, prison official, and IT support staff. Now this is the architecture of Nyaya Shruti. In this, lot of services are visible, right? For example, VC services. So the system is uniformly designed, okay, so that each stakeholder understands their own responsibility and integration part is handled with that stakeholder. So suppose scheduling, so all these APIs will be integrated in CIS system, like VC room creation, waiting room creation, attendance recording and streaming, time stamping. All those will be through VC services. Second is the scheduler service, that to be scheduled on what? So it always will be scheduled on the cause list or even the last time entries. That can also be done. So cause list for the day of for the court, selection of the parties, then attendance if required. So those services are consumed at the scheduler level. Now VC links to domain. So that goes through the integration only. So what we will do, we have API integration. The moment VC is created, the other domains like police, prison, forensic, prosecution, they receive alert on their dashboard that this VC has been called up by the court. Now this is pre-scheduled VC. Okay? So let's say tomorrow there has to be VC and today the schedule is ready. So for all those cause lists, these stakeholders will start running their schedulers and have all those VCs ready-made into their dashboard. And the moment person logs in, he will see that this VC has to be joined. So this integration is already done in police, prison, forensic, and prosecution. So some demos are going on, and if Bihar is ready in future, then we can also integrate. Because prison, forensic, and prosecution are central, so it will not require a special effort for Bihar. So they can nominate person to have a pilot testing for this. For the police, yes, CCTNS, we need to put up the effort so that they can make the right pages where the VC alert system can come. Now VC links are always joined with the secured PIN, and only the allowed participant or the person or official linked with that case into that system will be able to join. So the responsibility of this is at the stakeholder side. Okay? Court may not know who is the actual current IO of that case. Suppose there is a transfer happens or some in-charge change happen. In that case, so that particular case is handled by which IO currently, that can also, or SHO wants to appear in place of that. So what we are doing, we are referring as of now case. But the facility is there to give exact person details also. So suppose for a witness and victim in the charge sheet, when it is submitted and these are collected, we call this electronic addresses. So if electronic addresses are collected, then this VC will directly have an alert on their mobile phones. Okay? The link will be there to join the VC. But to that level of electronic address capturing mechanism and mandate to be there from the start of the investigation and when they submit the charge sheet. Because we have seen the fields in the CIS system where when you select an accused or a witness for generating a summon or notice, it comes as the addressee mobile number and addressee phone number. So the fields are there. We assume that in future, if it starts coming, there will be a lot of automation that can be triggered directly to the person. It may be like we send the pending statement of their credit cards to the person. In a similar way, if there is a summon going on to their mobile apps, they are acknowledging it, and they themselves can understand that after this summon there has to be NBW or billable warrant. So this kind of ecosystem will start coming, but that too only for the person who are tech savvy or they have the digital presence somewhere in their life. But we have to deal with another set of people where it is not possible, so the system will be in hybrid also. Now we will go to the Nyaya Shruti court hearing workflow. I'll just go how it happens, like scheduling the virtual court VC. So I think Chief Justice Sir told that VC is not like just joining it, but it's a full protocol. Yesterday we got to know. So yes, it is a full protocol. It requires authentication, it requires scheduling, it requires cause list, it requires who is going to appear next, it requires attendance capturing. So all those mechanisms are established under Nyaya Shruti. So right now it is a scheduled hearing part. So right now it is Delhi Central Chief Magistrate, Metropolitan Magistrate. So suppose there is a scheduling of hearing happens. At this point of time, a meeting schedule is available, and that has been marked with a particular case. So in spite of getting through each of the steps, I will just play one of the video that will help you out.
Select your state. You will then see the login page. Enter your phone number and password, solve the CAPTCHA, and click Login. Next, you will see the court selection page. Choose your district and select the appropriate bench, then click Next. On the court listing page, select your court. Here, you can schedule hearings. Choose a date and click Schedule. After that, click here and Next to proceed. You will now see the list of cases. Click on the case numbers to add details such as the police station, prison, forensic team, prosecutors, and other relevant information. To add police station details, choose your district, then enter the police station name, time, and officer's name. You can also include the batch code, email, and phone number if required. And click this button to save. To add prison details, select your district, then enter the prison name, time, and prisoner name. You can also include the prisoner ID, superintendent's email, and mobile number. And click this button to save. To add forensic details, enter the forensic team name, time, and officer's name. You may also provide their email and phone number. And click this button to save. To add prosecutor details, enter the prosecutor's name and time. You can also include their email and phone number. And click this button to save. If you have any other relevant information, you can add it in the Others section. Then click on the back button and click Proceed to Meeting. Make sure your camera and microphone are on, then click Proceed. Click here to record the session. Click here to toggle your video on or off. Click here to mute or unmute your microphone. Click here to share your screen. Click here to create a secret room. Click here to chat with the bench clerk and share documents. Click here to end the session. Click here to access more options such as viewing statistics, reviewing, recording, copying the meeting in the user. Here to view participants in the secret room. Click here to add slide list. We wish you a smooth court session.
So this was about Nyaya Shruti. I'll quickly cover e-summon. So e-summon is yet another initiative under new criminal laws in which court issues summons and warrants and which directly lands to the state police dashboards, and all the addresses are mentioned there so that they can do a transfer within the district as well, and now we are given the transfer interstate as well. So if the nearest police station is not into their jurisdiction, they can transfer it through e-summon portal. So legal provisions are form of summon, BNSS section 63, section 64, section 70 and 71. Again, this will take you through the entire authentication, and the workflows which are available in this is process generation. The process has to be updated in N-step system. It comes to the ICJS. Now it is available for the state police to work on. State police will log into the portal. So this is a small video in which it can log in. So this is how it appears to the police for the summons. This is how the choose of delivery officers is done. And this is the entire dashboard, which was lacking in the, I think, previously we have no such mechanism to track, trace where the summon is pending. Now how it gets delivered. So the moment the summon is assigned to a delivery officer, The delivery officer has a mobile app in which all the summon cards appears with their overdue date and yet to completion date, that is the next hearing date appears. There the summons are visible, which are court signed, and the QR code is also maintained. These are the execution details which has to be served by the delivery officer. Then there is a on-screen capturing of the person who is receiving the summon. There is also geo-tagging facilities, time-stamped and location. Also there is a on-screen signature facility for which they can have a recording in the execution details, which is coming as a preview to the officer who has performed the summon. So this is one of the key initiatives in which we have digitized the end-to-end e-summon generation, syncing, allocation, delivery, and compliance to the court. So till now we will pause here, and I'd like to wrap up my session. If more time is provided, we can see later on for the other modules which are there. Thank you very much.
Thank you, Mr. Ranjan Kumar, for explaining to us as to how the justice delivery system is undergoing a significant transformation, and also as to how the traditional methods of investigation, evidence collection, court management in service of judicial processes are steadily giving way to a technology-driven systems that are more efficient, transparent, reliable, and citizen-centric. We have a paucity of time, so I'll quickly come to the next resource person, Mr. Ranjit Shankar Prasad. Sir, I invite you to share your views on the subject. Please, please, please.
Honorable Chair, sir, Co-Chair, sir, माननीय अध्यक्षगण सर, महानिदेशक विपाट बी राजेंद्र सर, अन्य पुलिस पदाधिकारी के पदाधिकारीगण, अभियोजन पदाधिकारीगण, अन्य सभी उपस्थित सम्मानित न्यायिक पदाधिकारीगण को मेरा सादर प्रणाम। समय की पॉजिटिव है, इसलिए मैं कुछ पहलू को जो है इस साक्ष्य पे चूँकि बहुत डिटेल भी बताया गया, इसके तकनीकी पहलू को, चूँकि यहाँ पे पुलिस पदाधिकारी और मुख्य अभियोजक भी उपस्थित हैं, इसलिए मैं यहाँ चाहूँगा कि इस साक्ष्य के बारे में कुछ थोड़ा बहुत उस पर ई साक्ष्य जो है, ई साक्ष्य नियमावली बिहार सरकार के द्वारा अधिनियमित किया जा चुका है, और उस जो है जिसमें 7 वर्ष से अधिक सजा है, उसमें ई साक्ष्य माध्यम से अनुसंधानकर्ता को जो अनुसंधान करना है, सर्च एंड सीजर हो, विटनेसेस का गवाही हो, ये जितना है वह ई साक्ष्य माध्यम से ही किया जाना है। 105 BNSS का 105 लें, 173, 176, 180, 185, 497, ये जितने भी धाराएं बताएं, इस धारा में जो है ई साक्ष्य माध्यम के ऐप से उपयोग किया जाना है और इसी से लिया जाना है। इसके तकनीकी पहलू के बारे में रंजन जी ने बहुत ही इलेबोरेट बताया, सिर्फ इसके व्यावहारिक पहलू के बारे में हम बताना चाह रहे हैं कि जिस प्रकार से ई साक्ष्य जो है, अगर जो है अनुसंधानकर्ता ने लिया हुआ जाके स्टोर हो गया उसके मोबाइल में, और जब तक कि वह अपलोड नहीं करेगा वह क्लाउड में नहीं जाएगा। ये 4 मिनट पर उसको जो है अपलोड करने का है, 4 मिनट पर उसको क्लाउड पे जाके अपलोड किया जाना है। जब ये अपलोड होगा और जब अनुसंधानकर्ता के द्वारा ये साक्ष्य न्यायालय में प्रस्तुत किया जाना है, इसके पहले अनुसंधानकर्ता को 63(4)C का सर्टिफिकेट लगाना है, जो कंपलसरी है। इसी बात पर हम यहाँ पे उल्लेख करना चाह रहे थे कि शेड्यूल ए जो भारतीय साक्ष्य अधिनियम का जो सर्टिफिकेशन का 63A एंड B है, तो किसी भी अनुसंधानकर्ता को ये जब ई साक्ष्य ऐप के माध्यम से जो इन्वेस्टिगेशन किया है, उसको जब न्यायालय तभी उसको ग्राह्य मानेगा जब उसके साथ 63(4)C में ए सर्टिफिकेशन ए लगा हुआ होना चाहिए, तभी उसको माना जाएगा ग्राह्य। 63(4) कहता है उसके बारे में कि वह ये सर्टिफिकेट देगा अनुसंधानकर्ता कि ये जिस डिवाइस से हमने ये किया है वह डिवाइस प्रॉपरली वर्क कर रहा था, रेगुलरली उसमें फीडअप था। ये इस प्रकार का एक सर्टिफिकेट दिया जाना होता है। ये सर्टिफिकेट के साथ जब न्यायालय में जमा होगा तभी होगा। उसके साथ एक हैज़ वैल्यू निकाल के डालना है। अनुसंधानकर्ता को जब 63(4) का शेड्यूल ए देखा जाएगा उसमें हैज़ वैल्यू का एक चर्चा है। उसमें लिखा हुआ है कि पहले एक सर्टिफिकेट देना पड़ेगा। 63(4) जब हम लोग देखेंगे तो उसमें पाएंगे कि उसमें 4 कॉलम है कि ऑनर, जो अगर जिसका अगर मोबाइल है वह ऑनर, मेंटेन, मैनेज और ऑपरेटेड। ई साक्ष्य माध्यम से जब भी वह दिया जाएगा तो अनुसंधानकर्ता को ये ऑपरेटेड पार्ट है, उस ऑपरेटेड पार्ट में टिक मार्क करना है। उसके साथ उसमें एक हैज़ वैल्यू निकालना है और हैज़ वैल्यू निकाल के उसके साथ उसको सपोर्ट देना है, तभी वह न्यायालय में जाके ग्राही होगा। क्योंकि न्यायालय या इलेक्ट्रॉनिक एविडेंस के केस में सबसे अधिक इम्पॉर्टेंट ये है कि 3 चीज़ का ये जो होना चाहिए कि ऑथेंटिसिटी, इंटीग्रिटी एंड रिलायबिलिटी। अगर कोई इनकी जो है इलेक्ट्रॉनिक एविडेंस है, ये तीनों अगर क्राइटेरिया फुल नहीं होता है तब तक वह न्यायालय में प्रदर्शन नहीं होगा। रिलेवेंट और जो एडमिसिबिलिटी एंड प्रोबेटिव तो बाद में आता, पहले हम लोगों को ये तीनों देखना होगा कि उसकी ऑथेंटिसिटी, इंटीग्रिटी एंड रिलायबिलिटी है क्या नहीं, ये प्रूव करना होगा। इसलिए 63(2) में जो दिया हो गया मैंडेट, उसी को 63 जो ए में सर्टिफिकेशन है उसी क्लॉज में अनुसंधानकर्ता को देना है और इसके साथ एक हैज़ वैल्यू निकाल के देना है। एस वैल्यू में SHA 1 है, SHA 256 है, MD5 है, इसको लगा के देना है। SHA 256 SH मतलब हो गया सिक्योर्ड हैश एल्गोरिथम। 256 अगर करते हैं SHA 256, इसका मतलब है 256 बिट जो है वह टोटल जो है वह 64 कैरेक्टर में उसको बदल देता है। तो ये एक सर्टिफिकेट जो है उसके ऑथेंटिसिटी एंड इंटीग्रिटी के लिए वह सर्टिफिकेट जब लगा के दिया जाएगा तभी वह ई साक्ष्य ऐप का, जबकि ये जो है ई साक्ष्य माध्यम से कलेक्ट किया गया एविडेंस ये प्राइमरी एविडेंस की श्रेणी में आता है, वह इररिफ्यूटेबल है। डिस्पाइट दिस फैक्ट ये जो है देना पड़ता है, जबकि ये सेकेंडरी एविडेंस नहीं है। लेकिन लेजिस्लेचर ने कहा है कि जब भी आप ई साक्ष्य माध्यम से कीजिएगा तो ई साक्ष्य ऐप के माध्यम से आपको एक सर्टिफिकेट लगा के, इसीलिए जो ई साक्ष्य नियमावली भी जो बनी हुई है उस साक्ष्य बिहार सरकार के द्वारा या भारत सरकार ने जो अपना मॉडल ड्राफ्ट बना के दिया था उस मॉडल ड्राफ्ट में ये बात लिखा हुआ था 64C पार्ट में जो है शेड्यूल लगा के उसका एक आपको सर्टिफिकेट अनुसंधानकर्ता को देना है। और वह जब ए में हैज़ वैल्यू है, वह हैज़ वैल्यू एक फिंगरप्रिंट हुआ, इलेक्ट्रॉनिक फिंगरप्रिंट हुआ, उसको लगा के दिया जाना है, तभी जो है उसको प्रूफ एग्जिबिट माना जाएगा। ये बहुत ही इम्पॉर्टेंट चीज़ है। इसलिए अनुसंधानकर्ता जितने पुलिस पदाधिकारी उनसे मेरा विनम्र अनुरोध होगा कि जब भी जो ई साक्ष्य ऐप के माध्यम से देते हैं तो उसके साथ जो है 64 जो है C में जो एक सर्टिफिकेट लगा हुआ है उस सर्टिफिकेट को लगा के देना है, डिस्पाइट कि यह प्राइमरी एविडेंस है जो सेकेंडरी है। और कल जो है माननीय सर्वोच्च न्यायालय में बताया गया था न्यायाधीशगण के द्वारा कि पुणे बार एसोसिएशन वर्सेस यूनियन ऑफ इंडिया के केस में भी माननीय सर्वोच्च न्यायालय ने यह स्पष्ट रूप से कह दिया कि हैज़ वैल्यू जो है वह अनकॉन्स्टिट्यूशनल नहीं है, उसको देना ही है। और 39 एंड 12 के बारे में अभी मई में ही जजमेंट आया है सुप्रीम कोर्ट के द्वारा, उसका थोड़ा सा क्रक्स हम बताना चाहेंगे। द ऑनरेबल सुप्रीम कोर्ट upheld the constitutional validity of section 63(4) of BSA mandating that digital evidence be accompanied by a standard form certificate to ensure authenticity and integrity. The Honorable Supreme Court rejected the Pune Bar Association's argument that the certification requirement imposed undue hardship on ordinary litigants. Part A requirement, the Honorable Court affirmed that disclosing the hash value of electronic record is essential. Acting as an electronic fingerprint, the hash value ensures digital evidence has not been tampered with. और जो मद्रास हाई कोर्ट के द्वारा 79A का जो दिया गया था कि उसके लिए कि जो एक्सपर्ट जो भारत और राज्य सरकार के द्वारा दिया गया उसी का तभी मान हो गया, उसको भी जो है माननीय सर्वोच्च न्यायालय ने इस बात को भी ये नहीं कहा कि नहीं 79A जो है उनके अंतर्गत जो भी एक्सपर्ट है ये नहीं है कि भारत और ऐसा संभव नहीं है जो साइबर पर और कंप्यूटर पर एक्सपर्ट है वह भी उस पर एक सर्टिफिकेट दे सकता है। इसलिए ई साक्ष्य नियमावली में जब भी दिया जाए अनुसंधानकर्ता से अनुरोध होगा कि वह एक सर्टिफिकेट लगा के सबमिट करे ताकि उसकी ऑथेंटिसिटी और इंटीग्रिटी बनी रहे। और हेज वैल्यू के बारे में माननीय सर्वोच्च न्यायालय ने भी स्पष्ट रूप से अपना कर दिया। हाउएवर अदर रिलेवेंट पार्ट संदर्भ में था न कि जो है इस एक्ट ऐप के संदर्भ में था, वह उसमें पुणे बार एसोसिएशन में जो है वह पुणे बार एसोसिएशन के द्वारा कहा गया था कि ये 39 में जो लिटिगेंट 39(1) VSA में जो एक सर्टिफिकेशन देने की आवश्यकता होती है, चाहे वह कोई ऑर्डनरी मैन को भी अगर कोई होता है उसको अगर सबमिट करना है तो उसके लिए 39(1) में एक सर्टिफिकेट देना होगा जिसमें ऑर्डनरी मैन को भी एक हैज वैल्यू निकालने की आवश्यकता हो जाती है। तो उसी में उन्हें पुणे बार एसोसिएशन में कहना था कि ये कहाँ से जो है ले मैन कहाँ से निकाल के देगा ये, इसलिए ये अनकॉन्स्टिट्यूशनल है, इसको ख़त्म कर दिया जाए। लेकिन माननीय सर्वोच्च न्यायालय ने कहा नहीं हैज वैल्यू जो है निकाल के देना ही होगा और हैज वैल्यू सर्टिफिकेशन A एंड B दोनों जो है B जो फॉरेंसिक या एक्सपर्ट के द्वारा दिया जाएगा और 39(1) जो है जो भी प्रोड्यूस करता है, चाहे वह ऑनर हो, मेंटेन करता हो, चाहे मैनेज करता हो, चाहे ऑपरेटेड पार्ट में आता हो, उसको सबमिट करना है। तो ये एसेंस जो है कि इस एक्ट के संदर्भ में कुछ इम्पोर्टेंट पहलू था जिसको कि हम चाह रहे थे कि जो है अनुसंधानकर्ता और चीफ प्रोसिक्यूटर को दें ताकि रोज के काम में इसका जो है उपयोग करें। इसी समय पाबंदी के कारण मैं अपना वाणी यहीं पर समाप्त करता हूँ।
Thank you so much. Thank you, Mr. Ranjit Shankar Prasad, for explaining the entire thing as to how evidence is to be collected under e-Sakshya and how e-Sakshya seeks to provide a secure and legally compliant mechanism for handling electronic evidence in accordance with the requirements of the Bharatiya Sakshya Adhiniyam. Thank you so much for sharing your views and explaining things to us. Now, I'll request my brother, Honorable Mr. Justice Surendra Pandey, who has been co-chairing this session, to give his concluding remarks. Brother.
Good afternoon, Honorable Chair, Honorable Mr. Justice Rajiv Ranjan Prasad, JAD2, and Chairperson, Bihar Judicial Academy, my honorable brother and sister judges, officers of the prosecution from the police, and all the participants, ladies and gentlemen. As we come close to this session, it is my duty to offer a few concluding remarks. The deliberations today have demonstrated that the integration of technology into the justice delivery system is no longer a matter of choice. It is an institutional necessity. However, the recurring theme throughout the session has also been that while technology may transform the process, it cannot dilute the foundational principles of fairness, legality, and judicial scrutiny. The discussion on e-Sakshya reminded us that electronic evidence has become central to the adjudication of criminal cases. As our chair clarified, and even the other speaker, the adjudication, the mobile phones, the CCTV footages, the GPS data, digital documents, and electronic communications frequently constitute the most crucial piece of evidence. Yet their evidentiary value depends not merely on their existence, but on their authenticity, reliability, and integrity. Our courts have consistently emphasized this principle. I am not going to repeat the various judgments, though I had noted it, seeing the paucity of time. I would skip that. And I'll come straight to the deliberations which has just been made. I'll be referring to initially our chair. He highlighted the requirements of the e-Sakshya, the e-Summons, and the CIS, which has significantly enhanced judicial proceedings as has become the backbone. These initiatives as proposed by the chair, was an embody on shift towards judicial system that is efficient without compromising fairness. He highlighted the need of Nyaya Shruti, describing it to be a progressive initiative for improved communications with victims and witnesses. Our first resource person, Mr. Ranjan Kumar, through his enlightening talk through visual presentations, dwell upon software modules. I won't again elaborate it, but he had referred the e-Saksha, the Nyaya Shruti. He took us along with the slideshow, showing us how easy the whole process is to use the mobile apps, including the e-Saksha, how the e-summons are to be served. So that has clarified the doubts which we had in our minds, because there was one question in our minds, in fact in every person's mind, that whether these would be a foolproof. But as our resource person took us along, we got to know that this app, if is used as it has been designed to, it would be a very convenient device for us to facilitate the entire judicial proceedings, right from filing of the FIR till the final pronouncement of the judgment. The other learned speaker, Mr. Ranjit Shankar Prasad, he abided by the time which was allotted to him, and I'm thankful, sir, that you considered that. But he has highlighted a very, very important point, that the practical aspect of the Saksha, because we have been seeing the process, the architecture of it, but he highlighted the practical aspects. He also referred to the Supreme Court judgments, where the observations have been made, the directions have been made, how to use it, and we should be using it. So that this session now comes to an end, and with the things which we have just noted down, that today's deliberation reminded us that judicial officers must remain conscious of issues relating to data security, privacy, cyber security, and the protection of individual rights. Digital systems undoubtedly improve efficiency, but constitutional values must continue to guide our technological interventions. Ultimately, the success of these initiatives will not be measured by the sophistication of the software, but by the confidence of the litigant who experience a justice delivery system that is accessible, transparent, and responsive. I sincerely thank our Honorable Chair, whose guidance has enriched today's proceedings, and our distinguished speakers who have translated complex technology concepts into practical judicial tools. I also congratulate the participants who had attended this session, and I hope that we would be taking a good experience from this session. I am reminded of the timeless observations of Roscoe Pond that law must be stable, but yet it cannot stand still. That thought perhaps best captures the spirit of this session. Our legal principles remain steadfast, but the methods by which we administer justice must evolve to meet the demands of a changing society. With these words, I thank every one of you for your active participation and wish you every success. Thank you all. Jai Hind.
Thank you, brother, for so beautifully recapitulating and summarizing the views expressed by all the speakers.
One question is
I'll come to that, sir. I'm just so nicely recapitulating all the views expressed by the speakers, and also for sharing your insightful thought to the topic of the session. Yes, brother, you had one question.
One question is from Sri Ranjit ji, because Ranjit ji have categorically indicated कि साहब ई साक्ष्य लेते समय जो भी आईओ हैं वो 4 मिनट का क्लिक अपने मोबाइल में रखेंगे और उसको वो फिर क्लाउड में देंगे. तो आपका ये कहना था कि क्लाउड में देते समय नेसेसरली सर्टिफिकेशन देना है जो बीएसए में है.
नहीं, तो क्लाउड के समय नहीं सर, हम
हमारा ये कहना था कि जब भी ई साक्ष्य के द्वारा जो एविडेंस कलेक्ट किया गया और उसको न्यायालय में जब सबमिट किया जाने लगेगा तो न्यायालय में सबमिट किए जाने के समय एक 64C का जो सर्टिफिकेट है वो लगा के न्यायालय में सबमिट किया।
हाँ ठीक है, हम उसी में पूछ रहे हैं कि ई सर्टिफिकेट लगाना है, ऐसा आपने बताया, होना भी चाहिए।
सर ई साक्ष्य में है दिया हुआ, रूल्स बताए सर हम।
अब ये नहीं, अब मेरा ये कहना है
सर
कि ये आम जिंदगी में ये है कि लेट अस सपोज आईओ ने 4 मिनट का एक क्लिप लिया, उसको दिया, लगा के दिया, और सब्सिक्वेंटली आईओ बदल गए, और आईओ बदलने के बाद उन्होंने फिर 4 मिनट के दूसरे कई गवाहों की गवाहियां ली। तो मेरा 2 प्रश्न है कि जिस 4-4 मिनट की गवाहियां उन्होंने ली दूसरे गवाहों की 161 में, तो वो सर्टिफिकेट अलग अलग देंगे या चारों का एक ही सर्टिफिकेट देंगे? प्रश्न 1। दूसरा प्रश्न है कि जैसे मान लिया जाए अगर आप कहते हैं एक देंगे, तो चार्जशीट फाइलिंग के समय जो पुलिस रिपोर्ट, वो जो डिजिटल पुलिस रिपोर्ट देंगे, उसके बीच अगर 3 आईओ बदल गए तो तीनों आईओ अपना अलग अलग सर्टिफिकेट देंगे जो अपना काम किया, कि पूरे केस का एक ही सर्टिफिकेट देंगे? ये बताने की कृपा कीजिए।
हाँ सर, हम सर इसमें क्लियर कर दें सर, हम लोग जो ये सर्टिफिकेट दे रहे हैं वो डिवाइस के दे रहे हैं। जिस डिवाइस से ये कलेक्ट किया गया वह डिवाइस में कोई पहले से उस प्रश्न उठ सकता है, ये जिस डिवाइस से आपने एविडेंस कलेक्ट किया है, क्या वह डिवाइस जो है वह इन्फेक्टेड नहीं था, पहले से टेम्पर्ड नहीं था? उस डिवाइस को, उस डिवाइस के हम देते हैं कि ये डिवाइस प्रॉपरली यूज 63
मेरा प्रश्न ये नहीं है, मेरा प्रश्न है कि जब आईओ बदलेगा सब आईओ अपने अपने मोबाइल से रिकॉर्ड करेगा।
अगर डिवाइस चेंज हो जाएगा तो सर्टिफिकेट देना होगा।
तो मतलब ये है कि ये बात एक्ट में है कि डिवाइस
नहीं सर, ये एक्ट में नहीं है।
मतलब ये है कि आईओ बदलेंगे तो निश्चित रूप से उनका मोबाइल नंबर बदलेगा, अलग अलग।
ये सर ये इसमें ये जो है नियमावली जो बनी हुई है, ये भारत सरकार के द्वारा जो ये बना हुआ था, इस बात को इसमें ये इनकॉर्पोरेट नहीं।
क्या होना चाहिए?
यहाँ तक मेरा अपना सोच है सर,
रूल में भी, नियमावली में भी इनकॉर्पोरेट है, आई एम अवेयर, लेकिन चूंकि यहाँ हर स्टेक होल्डर बैठे हैं, तो मैंने ये फायरिंग, ये फ्लैग इसलिए उठाया कि ये प्रैक्टिकली ये प्रश्न आ सकता है, तो उसमें क्या होना चाहिए? हम ये सभी के लिए आंसर है। एनआईसी के एक्सपर्ट बैठे हैं, इसलिए उनसे भी ये है कि वो भी इस पर कहें।
सर एक इलेक्ट्रॉनिक एविडेंस का जो गवर्निंग प्रिंसिपल है सर, गवर्निंग प्रिंसिपल है, जब भी डिवाइस अगर चेंज होगा, जब भी अगर वह साइमल्टेनियसली अगर एक जगह से दूसरे ये जाता है, तो हैज वैल्यू क्रिएट होना चाहिए। ये इलेक्ट्रॉनिक एविडेंस का एक जनरल प्रिंसिपल।
तो हम ये समझें कि आपका ये निर्देश है कि जब लगता चेंज होगा या जब 4 मिनट का एक क्लिप होगा, उतना सर्टिफिकेट लगता चला
उतना नहीं सर। अगर इलेक्ट्रॉनिक एक डिवाइस से इन्वेस्टिगेटिंग ऑफिसर, एक इन्वेस्टिगेटिंग ऑफिसर कर रहा था और एक इन्वेस्टिगेटिंग ऑफिसर के द्वारा अगर दूसरे इन्वेस्टिगेटिंग ऑफिसर को दिया जा रहा है, अगर मोबाइल या डिवाइस चेंज हो जाता है, क्योंकि डिवाइस का सर्टिफिकेशन है ये, न कि उसमें कंटेंट का सर। जो डिवाइस का जो उसमें सर्टिफिकेशन है सर, हम डिवाइस में कोई मैन्युफैक्चर नहीं किया गया, तो पहले से कोई टेम्पर्ड नहीं था। ये 63(2) का हम डिवाइस के जेन्युइनिटी के बारे में बताते हैं कि ये जो है ये पूरा रिलायबल है, इंटीग्रिटी इसका जो है उसको हम डिवाइस का देते हैं। अगर सर डिवाइस जब भी चेंज होगा तो उसका एक सर्टिफिकेट, मेरे पॉइंट ऑफ व्यू से वैसे इसका नियमावली में या भारत सरकार का जो मॉडल ड्राफ्ट है उसमें चर्चा नहीं थी सर। लेकिन यहाँ तक इलेक्ट्रॉनिक एविडेंस का गवर्निंग,
टेक्निकल पर्सन मैं चाहूंगा कि वो भी इस पर बोले, टेक्निकल पर्सन की ये जो प्रश्न है उससे क्या इन्फ्लुएंस होगा।
Mr. Ranjan Kumar also wants to share his views on this topic. Basically what Mr. Ranjit Shankar Prasad is saying, that the certificate is for the device. It certifies only the device, not the evidence collected. So that is the emphasis that he is saying. The moment the device changes, it will require a fresh certification. So, but he has something to say. Mr. Ranjan Kumar.
Thank you, sir. First of all, sir, video 4 minutes is not a compulsion. आपका वीडियो 5 मिनट 10 मिनट का भी होगा, बैकग्राउंड में वो 4 मिनट्स की चंकिंग है, ठीक है। सो देयर विल बी स्मूथ ट्रांजिशन टिल 1 आवर ऑल्सो, ठीक है। दूसरा है सर, ये भी पॉसिबिलिटी है कि आईओ ने एक मोबाइल पर रजिस्टर किया था, मोबाइल अगर वर्किंग नहीं है दूसरे मोबाइल में वो आ गया है, तो सर जब उसमें SID क्रिएट करते हैं उस डिवाइस के हिसाब से 63(4) जनरेट होती है ऑटोमेटिक। तो सपोज कीजिए जैसे ही वो एक FIR से 20 SIDs को लिंक करता है, जिसमें से 10 उसने एक डिवाइस A से किया है, 10 उन्होंने डिवाइस B से किया है, आप हर SID पे जाके 63(4) को इन्वोक कर सकते हैं, वहाँ पे लिंक है।
तो कहीं पे कोई ऐसा प्रश्न नहीं है, सपोज आयो भी चेंज हुआ तो कोर्ट के सामने जब वो प्रस्तुत होगी तो वो किसने कब कैसे कैप्चर किया है वो डिटेल भी उसमें है हैश के साथ। तो आपको आयो 1 आयो 2 भी दिखेगा, सब्सिक्वेंट भी दिख सकते हैं। तो सर मैं यही कहना चाहूँगा कि जितने भी SIDs क्रिएट होंगे उसके साथ 634C अपने आप जनरेट होगा। इसमें ऑलरेडी प्री डिफाइंड मेटा डेटा मेंशन्ड है और किसी भी केस का ये पूरे हायरार्की में मेंटेन होगा जैसे ही वो लिंकिंग कर देते हैं।
यानी आपका कहना है कि जैसे ही क्लाउड में जाएगा तो NIC ने जो सिस्टम जनरेट किया है वहाँ ऑटोमेटिक जनरेशन है।
यस ये सिस्टम खुद जनरेट कर रहा है और इसको हमने PDF में प्रिंटेबल भी दिया है सो दैट चार्जशीट के साथ प्रिंट निकाल के आईओ सबमिट कर सके।
और ई-साक्ष्य ऐप वो सारे आईओ ने अपने मोबाइल में
डाल रखा है। इवन उनके कोई और ऑफिसर है, सपोज ही इज वेरी इंगेज, जो कि फील्ड में जाके कलेक्ट करना चाहते हैं,
हाँ।
उससे भी वो कलेक्ट कर सकते हैं। उसकी भी 643C डिफरेंट होगी, ठीक है, और जिस पर्सन ने लिया है वही होगी, बाद में उसको आईओ अप्रूव कर सकता है। ये मैकेनिज्म भी एस्टैब्लिश्ड है।
तो डिजिटल सिग्नेचर उसमें ऑलरेडी इनबिल्ट है जिसका मोबाइल है।
यस आप इक्विवेलेंट टू डिजिटल सिग्नेचर।
I think that satisfies brother Anshuman. I think brother Rajiv Ranjan Prasad also has a question.
My question is with Sri Ranjan Kumar ji. See, we are storing the data or the pictures in the iCloud. So what are the chances of tampering with those evidences, particularly when it is in the state domain? So you just... Yes, sir. Sir, this is an immutable storage. It means that you have write once facility only. So suppose there is a memory location that takes, suppose 5 MB of data. During that specified space, if anything has been written, nothing else can be written again. So there is no possibility of tampering because that memory location itself won't be available for the new incoming object. Then another question, how a normal person, a general person can find out the hash value? Suppose I have stored something in my mobile, I have taken a picture and I am giving it to someone and I have to write on the certificate which I am issuing the hash value, then how I'll get that hash value? Sir, that is why you must have eSaksh mobile app installed, because this app only gives the standardized creation of the hash value along with the unique timestamp based SID creation. Because this is not doable by any person. Like he cannot generate hash automatically because he doesn't have any idea. It has to be done by some software mechanism, taking all the fields, making a hash. It can choose either of the algorithms, and then it can present to the reports that this is the hash of this, which is giving. So if suppose I am moving on the road and I find that something is happening, I take a picture, make a video out of that. So I will not have any hash value in my mobile? No, sir. Then that would not have any evidentiary value? No, sir. You must have those visual captured through eSaksh mobile app, which will already enable you to give a hashed value along with the video which you have taken. Then every citizen should have that eSaksh app in his mobile? Sir, is it required for everyone to submit the same? No, suppose it may happen anywhere. Suppose something is happening in someone's house. Somebody has entered into the house and he is committing an offense. Then one of the members of the family is taking a video of that. As we find every day, it comes on the social media. Right. So if a member of the family is taking a video, preparing a video clip, and that is handed over to police on a pen drive or something like that, that will not have any evidentiary value? Sir, then you have to invoke 634C Part B. There you must engage an expert to validate whether any morph clip has been incorporated, any distortion with the video has been done. Because suppose there is some incident going on in the video and that has been hidden with some objects, we cannot identify. Also there are applications, third-party tools which can alter the positions of the person, the object's direction, which can give you
reverse picture.
So in that case,
has
the mobile should go to the FSL.
Yes, in that case, you must have to get it verified by the experts.
That requires a
So that is what e-Saksh has eliminated.
Yes.
It indicates to a mathematical algorithm which cannot be reversed. This what hash value
Yes.
is supposed to be.
Yes,
It
it's
cannot
like
be reversed.
yeah. It's like you have a funnel and you put something into it, it becomes a different product. Okay, now with this product you cannot get out of the raw material. The raw material has already given you something encrypted. With this encryption you cannot regenerate that. So we have to take a strict mathematical algorithm. Even though it is possible, it must take years at least. Okay, 10 years, 20 years of the time for the computation.
So it's need an expert too. I mean, one cannot come up with it unless.
No. Unless you have the same thing with this, but that has to be with the same metadata like time stamping, latitude, longitude, everything. Suppose 2 images are taken, your 2 images, that will generate a different hash because the moment it has been taken, the position at which it has been taken, the intensity, suppose the angle of mobile has changed. Okay. So the bits variation will be there. The value of color combination will change. So it will always give you a different hash.
So every subsequent change will create a new hash.
Yes, definitely. Only the retrieval can guarantee. Only the retrieval guarantees that, suppose whatever you have given somewhere, you are retrieving the same thing. That guarantees that these two things are same. So whenever we query with the SID, it gets converted into hash.
I think brother is satisfied. Due to a paucity of time, it would be difficult to take any further questions because we have our next session. You can discuss with him, individually. So because otherwise we are encroaching on the time of the next session. So that doesn't look nice. So I think we are through with the question and answer session, and this session concludes over here. Thank you so much.
सर मोबाइल नंबर सर का भेजवा दिया.
Thank you, Lordships and distinguished speakers.
I think Sanjay ji का मोबाइल नंबर सर्कुलेट कर देंगे. People can directly approach him for the answers.
Thank you, sir.
Respected delegates and participants, we have now reached the scheduled tea break. I request all participants to kindly reassemble in the auditorium sharply at 12:30 so that we may commence the final technical session on schedule. Deliberations have traversed the substantive provisions of the new criminal laws, institutional coordination, statutory timeline, technological innovations. The final technical session looks ahead and focuses on strengthening the institutional framework necessary for successful implementation. Digital infrastructure, continuous capacity building, and a uniform technology adoption strategy across district are indispensable for realizing the objectives of the new criminal laws. We shall now commence with the final and the fifth technical session. May I most respectfully invite Honorable Madam Justice G. Anupama Chakravarti, Judge, Patna High Court, to kindly grace the dais and preside over this technical session as the chair. May I respectfully invite Honorable Mr. Justice Harish Kumar, Judge, Patna High Court, to kindly grace the dais as the co-chair of this session. May I respectfully invite Shri Ajitab Kumar, Additional Director General, SCRB and Modernization, Bihar, to kindly grace the dais. May I also respectfully invite Dr. Anant Prabhu Ji, Cyber and Security Expert, to kindly grace the dais. May I further invite Shri Pranav Shankar, Joint Registrar List, Patna High Court, to kindly grace the dais. We shall now proceed with the felicitation of our esteemed dignitaries on the dais. May I request Shri Bharat Bhushan Bhasin, Director, Bihar Judicial Academy, to felicitate Honorable Madam Justice G. Anupama Chakravarti, Judge, Patna High Court, with a planter and memento. May I request Shri Subhash Chandra Sharma, Director, Administration, Bihar Judicial Academy, to felicitate Honorable Mr. Justice Harish Kumar, Judge, Patna High Court, with a planter and memento. May I request Shri Mukesh Kumar, Deputy Director, Bihar Judicial Academy, to felicitate Dr. Anant Prabhu Ji with a planter and memento. May I request Shri Nishikant Thakur, Additional Director, Bihar Judicial Academy, to felicitate Shri Ajitab Kumar. With a planter and memento. I request Ms. Pallavi Anand, Administrative Officer, Bihar Judicial Academy, to felicitate Shri Pranav Shankar, Joint Registrar, List, Patna High Court, with a planter and memento. The floor is now handed over to the respected chair, Honorable Madam Justice G. Anupama Chakravarti, Judge, Patna High Court, to moderate this technical session. Leadership.
My pranams to the Honorable Justice Sri Rajiv Ranjan Prasad, JAD2, Patna High Court, come Chairman of Bihar Judicial Academy, to my co-chair brother Harish Kumar, and to all the brothers and sister judges of Patna High Court, distinguished speakers on the dais, Mr. B. Rajender, Director BIPARD, all the respected judicial officers, officers from the police department, other stakeholders, ladies and gentlemen. It's a privilege and a pleasure to welcome you all for the last session of today's conference. Our deliberations have already highlighted the successful implementation of criminal laws from the past 2 days, and today's session focuses a role on technology in strengthening the administration of criminal justice system. It requires transformation of our system, our process, most importantly, our institutional mindset. I consider it as an honor to introduce the distinguished resource persons. We are privileged to have Sri Ajitab Kumar, IPS Officer 1997 batch of Bihar cadre, presently serving as Additional Director General, State Crime Records Bureau and Modernization, Bihar. We are equally honored to welcome Dr. Anantaprabhu Gurpur, a distinguished academician, cyber security expert, and an internationally recognized authority of fields of digital forensics, cyber security, and cyber law. We also have a pleasure of welcoming Sri Pranav Shankar, Officer of Bihar Superior Judicial Service, presently serving as Joint Registrar List of Patna High Court, who is closely associated with the administration functions of the High Court. The new criminal laws innovation in a justice system is more transparent, more efficient, more equitable, and more citizen-centric. However, we must acknowledge the realities of the ground, variations of infrastructure across the districts, connectivity issues, shortage of trained personnel, cyber security concerns, and need of continuous technical support remain significant challenges. Learning is everyday process for all of us. The topic assigned to us, though overlapped with the other sessions, I would like to deal with certain provisions of law in all the 3 new laws, criminal acts, which are under the challenge. BNSS 2023 introduces technology-driven criminal justice system by integrating digital process at almost every stage from the date of registration of the crime, investigation, trial, and delivery to the judgments. It starts with e-FIR and zero FIR. Section 173 of BNSS deals with the filing of registration of electronic first information report with respect to cognizable offenses. And once an information has been given through electronic communication, registration of the case will be done with respect to the said e-FIR, and within 3 days of its report to be processed, and it enables for the registration, it also enables for the registration of zero FIR irrespective of technical jurisdiction, and it has to be transferred to the concerned police jurisdiction, police station having territorial jurisdiction for investigation. The next section deals with section 73 of BNSS, electronic service of summons. Already the other co-speakers of the either previous sessions have already dealt with it, but still the summons have to be attested and kept as a proof of service also has to be kept under the said section. Section 530 of BNSS allows the entire trial, including issuance, service and execution of summons and warrants, to be conducted by electronic mode using audio, video or electronic communication. In Bombay, the Bombay High Court in the state of Maharashtra versus Satish 2026 SCC online Bombay 1419 has clarified that summons served through electronic means include mobile communication are legally valid under BNSS 2023, and that the criminal courts must align their procedure with the digital framework introduced by new law. Holding the object of a summons is to ensure that the witness receives the notice of the proceedings and not to insist on a particular mode of service. The court ruled that once such knowledge is communicated through legally recognized electronic method, the service cannot be treated as defective. Audio-video recording of search and seizure is dealt under Section 105 of the new provision of the Act. The word shall is used, which is mandatory to record the entire process of searching of the place or taking the position of any property, article, or thing through audio, video, electronic means. And it also extends to the searches carried under Section 185 of BNSS, and the proviso of Section 185 subclause 2 specifically provides that such conducted under this section shall be recorded through audio, video, electronic means, preferably by using a mobile phone. The next section which gives importance is Section 180, which allows for recording of statements by electronic means of the witnesses. 183 enables the magistrate to record the confessions and the statements through audio, video methods in the presence of the accused counsel. Section 254, 265 and 266 allows evidence and the witness's testimony to be recorded by audio, video means, especially in sessions and warrant cases, including the cross-examination. Video conferencing of the accused persons, witnesses, and experts can also be participated, and Section 530 BNSS gives ample opportunity for the criminal courts to conduct trials, inquiries, and proceedings using the electronic and digital communication platforms. The victim is also entitled to receive information regarding the process of investigation through digital and electronic means. Section 531 of BNSS gives ample opportunity for the victim to know about the investigation at every stage. The courts and the investigating agencies can call and deal with the electronic records and digital evidence. As far as BSA, Bharatiya Sakshya Adhyan 2023 is concerned, Section 61, 62, and 63 deals with electronic digital records recognized for the documentary evidence and special provisions for the electronic evidence. There are two landmark judgments in these sections. P. Gopalakrishnan alias Dilip versus State of Kerala 2020, the courts clarified that memory cards and pen drives are legally documents, not material objects. It is established that while an accused has a right to cloned copies of digital evidence, court must balance this with the victim right to privacy in sensitive cases. Under Section 62, the landmark judgment is Arjun Pandit Rao Kotkar versus Kailash Kushan Rao 2020. A constitutional bench ruled that the statutory certification is mandatory when producing secondary electronic evidence. The strict compliance of the requirement directly informs how Section 63 BSA is to be enforced. Section 63 deals with the admissibility of the electronic records, including computer outputs, data stored in the communication devices, and certificate requirement. Electronic records are now used as primary evidence before the court. And this is one of the biggest reforms under BSA. The expanded meaning of electronic record includes the information stored in computers, smartphones, servers, optical and magnetic media, semiconductor, memories, emails, voicemails, CCTVs, and other communication services. Even prior to the new acts, commencement of the new acts, in the year 2015, in the case law of Tommaso Bruno versus State of UP, the court held that modern investigations must rely on the electronic evidence like CCTV footages. If prosecution deliberately withholds available electronic evidence, courts may draw adverse inference against them. Electronic oral evidence. Oral evidence can also be through electronical means, enabling the witness, victims, and accused persons to testify through video conferencing. The proof of signature, electronic signature has been dealt under Section 66 and 73 of BSA. Unlike BSA and BSA, BNS is a substantial criminal law where the technology has been recognized and criminalizing the offences communicated through electronic means. BNS electronic records and electronic documents provisions are relating to the forgery, destruction of evidence, and fabrication of documents. Section 111 speaks about organized crimes. The offense of stalking includes monitoring and contacting a woman through electronic communication such as social media, emails, or messaging platforms. Destruction of electronic records is also an offense under the new act, and forgery of the electronic records. the challenges which are there before this court in day-to-day process of the trial court is that inadequate digital infrastructure. Yesterday in the inaugural session, the government of Bihar has stated that smartphones as well as the laptops are being provided to the police officials. In spite of it, many police stations, in spite of it, how to use the smartphones and the laptops for the purpose of recording the evidence has to be trained by the government itself. There is lack of training. Cyber security risks are there. Electronic records are vulnerable for hacking, malware, ransom, and unauthorized access. With the AI itself, anything can be tampered. On this aspect, I request my resource person, Dr. Anant Prabhu, to enlighten us how the hacking can be done, and he will be demonstrating us. The digital divide, citizens in the rural areas may be with having limited smartphones and internet services or digital literacy, and authenticity of electronic evidence is also there. These are the main issues which are being as a challenges before the court. Now I request the resource persons to enlighten us on these aspects. Initially, I call upon Sri Ajitab Kumar, IPS officer, to enlighten us on this aspect. Thank you.
Thank you, ma'am. You covered many points which I planned to tell, but anyway, all respected dignitaries on the dais, respected dignitaries in front of me, and participants. This part is regarding the technology introduced along with these new criminal laws. What are the challenges? How much are we prepared? How much homework we have already done? This is my topic. Now my presentation has three parts. The first part is challenges for digital adoption and solution for state level infrastructure. Digital adoption. This is the main challenge, the number one topic. Then capacity building roadmap. Again, when you adopt new technology, you have to have capacity. You have to train people. This is one big challenge. Then action plan for uniform implementation of technology and adoption of strategy across districts. Now, why this digitization? We know that earlier, whatever bottlenecks we had, one of the reasons was we didn't have a seamless interaction with each other. Hard copies were there, FIRs had to physically go to the court, then charge sheet physically has to go, then so many things were on the physical mode. And that took time. That became a bottleneck for speedy justice. So this was, I think, one of the core issues in these new laws. And here comes the use of technology, not only for speedy movements, but also for quality evidence, which ma'am was also talking about. So this is our main challenge. And on the other hand, we have got the police people or judiciary people. We have to be very, to upgrade ourselves to adopt those technologies. Now this first slide shows, for example, Bharatiya Nyaya Sanhita BNS. Now there are new things. One of them is, of course, new redefined offenses, community service as punishment, recognition of technology. In the BNSS, videography. For all the offenses where punishment is 7 years or more, the FSL team has to go to the PO. Time-bound investigation. Again, use of technology. It is unavoidable. Bharatiya Sakshi Evidence Adhiniyam, admissibility of electronic evidence. If you adopt technology, then admissibility comes into question. So this is another challenge. We all know this is ICJ's 5 pillars. Police, we are having software called CCTNS, forensics, software e-forensic, prosecution, e-prosecution, judiciary, prisons. In fact, even before these 3 laws, many of these things are already have been adopted to us. For example, CCTNS. CCTNS came to the police, I think, in 2018-19. We have got computers and some connectivities already there. But now new challenges are there. Some new apps have come. E-Saksh app. We all know. Our IOs are expected to go to the PO, take whatever videos and statements they have and upload it on this E-Saksh app. Nyaya Setu, Nyaya Shruti, e-summons, everything through electronic medium. This is a very detailed account of how all the different pillars have to use these apps. So naturally, our challenge is not just the hardware. How to use these softwares, how to be very conversant with use of these softwares. This is a big challenge. I told you just before that even before 2018-19 or since 2018-19, there are an initial infrastructure is there with the police. We have already have this infrastructure in 894 police stations and 380 higher offices initially. Now 968 police stations are covered. But the total of police stations is 1382. So we have to cover that gap. Similarly, many other offices are there with the judiciary and prosecution, jail. We have to cover that gap in terms of hardware. Now, from police point of view, these are some forms which have to be filled in the CCTNS. And you can see there are so many forms. Right from 0 fire to till the last, and even some more. Now, problem with our IOs are they are not conversant with how to fill these forms, and some of the forms are such that people don't even write it in their files. For example, लापता वस्तुओं की पहचान. They don't know. It's not written many times. So all these things have to fill, and IOs have to be trained that you cannot avoid. If the information is there with you, you have to fill it. And mind you, sir, every information that we fill here is being transferred in real time to the NCRB in Delhi. And people there are watching it on their dashboard. This I'll talk later in some detail. Now, as I told, these all things throw up challenges. Number one, now connectivity gap. Bihar has very low, comparatively low internet connectivity among major states. And on top of that, 75% of the population, about 75% of the population is rural. The connectivity comes in question for all the pillars to be linked to one center and then to Delhi, NCRB portal, or to each other, you require good connectivity. This is one big challenge. Now the second one, the speed. More and more apps are coming, you require more and more speed, bigger space. 50 Mbps is speed minimum internet. Till 150 Mbps where there are big police stations. There are, say, 500 FIRs being lodged every month. They require a speed, internet speed of 150 Mbps, more than 100 at least. This is one challenge. Legacy systems. Now we have to digitize all the records. We have adopted this digitization process since 2018. But what about the period preceding that? Then, as I told, 968 police stations, only 968 police stations have been integrated, but another big chunk remains, the gap remains. The total number is 1382. We are in the process, we are doing that. I mean, it will be covered within maybe a month. Legacy data digitization, as told, 2018 onwards, we have already done digitization, but before that, we have taken up the process 10 years at a time. In first phase, 2009 to 2018, we are digitizing the records. Now, after we do that, then we will go back. Another challenge, forensic capacity. Now, we all know FSL team has to go to the PO if the offense, the FIR talks about an offense, punishable with imprisonment of 7 years or more. They have to go to FSL. Now, for that, we require very good forensic infrastructure. Then FSL, then you have forensic science labs you require. In Bihar, right now 4 of FSLs are working, 9 more are coming up. Fortunately, we are not behind. We are among the best in the country. 4 FSLs are working in Bihar. We have got DNA analyzer machine also, and 9 more are coming. We got 51 mobile forensic vans, but more will be required. We are in the process of acquiring more. Another challenge. But the basic challenge here, the last one here, the human capital. Our police people, suppose I talk about the lowest ranked police officer, the ASI. He is a person who was originally a constable, but later on got promoted into ASI. Now he is eligible for investigating a case. Now imagine he hasn't handled a computer in his school days or college days. Now he is given a mobile and a laptop. He has to go to the PO, take the evidence, take the pictures, take the statements and upload it right there and then. Then next, he has to write case diaries online. You require typing skills, so many knowledge. So our main challenge, I think, hardware will do, no issue, connectivity, no issue. Our main challenge is enriching the human capital. Our police force, our brother organizations, we have to enrich them technologically. This is another big challenge. One of the, I told you, many IFF forms, the forms you saw, 24 of them, they are not filled. Maybe information is not there, or maybe they don't know. And this is reflected in the national dashboard, which is there with the NCRB. They see that you're not filling those forms. Then another challenge, funding. Funding, fortunately, we are not very far behind. Whatever we demand, but it will require continuous support. Hardware part, okay, one-time capital investment, but what about the software? I can tell you, I was also looking after provisioning part. One single software which is required for cyber security will come for at least 1 or 2 crore rupees, and just after 1 year they will say this has become outdated. Another 2 crore rupees, please. And the criminals who are, whatever they are doing, they are one step ahead of us. So we have to constantly keep upgrading in terms of not only hardware, but also in terms of software. So constant funding support is required. Fortunately, we are having it. Then second, there are procurement delays. Suppose, for example, before ICGS 2.0, which is selected to come maybe in October or later on, we are purchasing a lot new systems, new computers with better quality, because the load is going to increase manifold. We are in process of buying them. But again, supplies are limited, companies take time, procurement delays. So we have to prepare beforehand. But fortunately, we are on time, we'll do before that. Departmental coordination, again, all the honorable members of Judicial are sitting here. Continuous coordination is required, continuous. So that there is a seamless integration between all the software which we are using. As far because I'm the nodal officer, I'm required to call a meeting from all the 5 pillars and then see, is there any problem with them? So we have started a monthly review. So that all the members come together, whatever problems are cropping up, we'll sort them out. Now, I talked about challenges. Now, what were the solution? As of now, for example, number one, rural connectivity, which I said is very poor, relatively poor. And police stations there in far remote areas, so we have to connect them. And that too with good speed. As of now, we have got BISWAN, Bihar State Wide Area Network linkages in all police stations. And as a support, there is a broadband also. Whichever company is supplying best internet, maybe Airtel, Jio, they are having that capacity. So alternatively, if the BISWAN is not working, they fall back upon that. One big concern here is that we have to ensure a system where there is no breakage. We cannot afford breakage of connectivity even for a minute. So we have to ensure that system. Now, since then, when the ICGS 2.0 comes, the load is going to increase many folds. So we're working on an increased speed, internet speed, minimum 50 Mbps, maximum up to 150 Mbps. So we are talking to the BISWAN people, Bihar State Wide Area Network people. We are also talking to the private internet service providers. And we will ensure at least 2 sources of supply so that our connectivity never breaks. We cannot afford anything. This we are working on. Legacy systems, like I told, digitization of earlier years, records of earlier years, we are on the way, we are on the job. Forensic capacity, we have to increase. I told you, there are 4 FSLs, 1 FSL Patna and 3 RFSLs. Muzaffarpur, Bhagalpur and Rajgir are working already. And 9 more FSLs are coming up. We have got a policy of having an FSL at every range headquarters. Range roughly is co-terminus without division. Every division or range is going to have 1 FSL. Human capital. Now, nothing more to say. This is our main focus. So, a scheme of continuous, not only, say 1 day workshop is there. It will not help. People learn and then unlearn also. A continuous reinforcement, sessions after sessions required, offline, online, and we are on to that. We are doing that. Funding and coordination, what we already discussed. Now this is, I was talking about the challenges. These were the challenges. Human capital, procurement, hardware, software. Now, a bit more about capacity building roadmap. Guiding principles. What we'll do? Number one, train the trainer. The method is put up some trainers there in every district, so that people, whenever they have any problem, they have got a trainer in their own district near them who can easily be approached, who will solve their problem. So the first, our target is at least put one good trainer in each and every district. Whatever problem is there with any of the pillars, they will go and address. Blended delivery. Whatever delivery systems are there should be for all the pillars. Here I've written, I got Karma Yogi platform. You very know it. These are some methods whereby we can impart such trainings which will be, useful for everyone. Role-specific content, again, here is a bit of difference. Police people have to be very conversant with these FIR forms, the methods, how to upload the evidence on the e-Sakshi app. E-Summons app is there, whereby someone is seen in a police station and they have to quickly endorse it to a police officer, and that police officer has to do the rest part and report back in the same portal. And continuous reinforcement means continuous training. Now, what action plan is there? At the top level, we are going to have state level steering committee at the top level, because there has to be some permanent institution which regularly monitors the progress and addresses the issues at the top level. Maybe it will be chaired by the Home Department, DGP, and with all other pillars and all other relevant departments, the Telecom Department, IT. There will be this top tier institution. Then at the local level. Now, every time top level tier cannot go to say address, say whatever problem is there in a block or in a deep thana. So every district has to have a committee, has to have a structure which will address them, which can be easily approachable. They can be chaired by the DM, SP, and other relevant people in the district level. And then we need a separate nodal technology cell. Again, technology word. We need to have technical experts with us. This one issue is very big. We are not technical experts. We will have real technical experts who know the use of software, who know the use of hardware, who know the problems in connectivity. A third tier is required there, maybe at the state level. Last part is now, after October, maybe over October afterwards, ICGS 2.0 is coming. This is going to be a wider application for us, which much better version than ICGS 1.0. Central integration of it will be centrally integrated, real time. The moment you upload an information, it will be visible there in Delhi or whatever, in their dashboard. Real time integration. Interoperability, seamless data. Whenever you interact each other, there will be no hiccups, no breakage. Immediately it will be visible to everyone, all the pillars. Real-time investigation, case updates. The moment the IO uploads the crime scene photos or your statements, it will be visible to all the others in real time, in no time. Unified and accurate data management. Again, a big improvement. Secure and controlled data exchange. Now, security, cyber security, one expert is, he will talk to us. Security of data is very important. This new software has got some features about security of the data we have. And then, solvable, intelligent and citizen-centric architecture. Many apps are there which are meant for citizen. One is Citizen Service Portal, which are using it. Every citizen has the right. They'll go to the app, they will upload their problem, and we have to take care of that problem and reply back in the same mode. So they don't have to go pillar to post. It will be like a delivery at the doorstep. These things are coming up. So this is a challenge which we are on the job, and by maybe October or November, we'll be seeing these things. As I told you, we are purchasing hardware, very high level end desktops, connectivities, digital scanners, UPS, and for all, most of the pillars we are purchasing, and it will be available by I think by the end of this month, or maybe by the next month. So we are welcoming ICGS 2.0. Hardware purchase items, desktop with UPS, very heavy desktops, mobile data terminals, the soft tab type of things where you can see everything, webcam, camera, multifunction printer, fingerprint roll machine, single device. They're all instruments, all gadgets which are to be used in the new system. All the 44 districts, there will be training centers, and all training centers will be having VC equipment, LED TVs, desktops. And then the new software is coming, which is called CAS 2.0. CAS is Core Application Software. We are using CAS 1. In fact, not as CAS 1 also. We have engaged a private system integrator. We are using their app. But once ICGS 2.0 comes, there will be one software for all police stations, all pillars across the country. There will be no variation. So a training program, for CAS 2.0 will be taken up. This is all I have. Actually, many things will also be told, but we are not having that time. If you want to ask something, then please. Okay, man. Thank you, man.
Thank you very much. And you have also enlightened us on the factual status of the Bihar State Police with regarding to the action plan and recommendations. Now I request Dr. Anand Prabhu to take up the next session.
Hello. A very good afternoon to all of you. Good afternoon, everyone. My obeisances to the honorable dignitaries on the dais and off the dais. How many of you have this fear that your phone might be hacked? Please raise your hands. A constant fear that somebody is recording what you're talking. A constant fear that your photos are being misused. How many of you? Please, hands up. Okay. I request you to please buy an iPhone. First point, buy an iPhone. Second, in iPhone, there is one option in settings called as lockdown mode. You have to enable that mode. This is the second thing you have to do. I repeat, buy an iPhone. How many of you are having iPhones? Hands up. Perfect. So, go to settings, privacy and security. There is an option there called lockdown mode. Enable that. Nobody in this universe would be able to hack your phone. Period. Till today. Settings. Go to settings. There is a search bar below. You just type lockdown mode. Okay? I will go a little fast because I think I only have 10 minutes. Next. Clarify. Thank you, sir. Done, sir. So settings. There is a search bar. Just type lockdown mode. Got it? Mil gaya? Perfect. Done it? So search phone is bulletproof from now. 100%. Nobody in the world would be able to hack. Period. Till today. Then you have not typed properly, sir, or you have not updated your operating system. One of the two. Updated? After I told, now how many of you enabled lockdown mode? Please raise your hands. Fantastic. Yeah, it will restart because it has to check if any issues are there, it will fix everything and it will make your phone bulletproof. So therefore the restart will happen. आप settings पे जा सकते हो sir और just type lockdown mode आ जाएगा sir. On the top it will come. Yes ma'am, it will restart. It will restart. Okay? Now the second point, I was listening to so many wonderful speakers and I was surprised to see a lot of you were taking down notes. I did not understand why. Instead, what you could do is just open this live transcribe in your Play Store. It is there in App Store also, but unfortunately they charge for it. In Play Store it is free. You can go to this app called Live Transcribe. Now every single word that I am typing is getting transcribed without a single mistake. Probably your stenographers may make mistakes, but this app will not make a single mistake. You can check it, you can open it, and the best part is after my today's session, you can go to ChatGPT and you can get the key points of every single point that I've spoken and also the actionable points that you will have to do so that your phone and other devices remain secure. Anybody has opened live transcribe on your phone? Opened? Whatever I'm speaking, word by word, is it coming? Perfect. Every single word that I'm uttering is getting transcribed there without a single mistake. And you will be able to get the key topics and the actionable points later on. Now third, sir, it is in Play Store it is free, in App Store it is paid, sir. This is the problem in Apple. So I am using a Android phone. My phone is S25 Ultra, Android. Why I will tell you in some time. Probably we will also change to Android after that. But the only problem is the security. Yes, ma'am? Now, would you want to watch one horror movie? All of you right now? Go to your phones, go to browser and type scan.aura.com. This will open in 90% of your phones. For some it may say available only in USA. You will have to use VPN to do it, but in 90% of your phones it will open. Just go to scan.aura.com and put your email address there. It will show your password. Yes. This is my horror movie for tonight. Go to scan.aura.com, type your email address there and run the scan. It will tell your house address, it will tell your mobile number, it will tell your password, it will tell your passwords, that is your previous passwords, and a lot more about you. You can see things which you didn't know about you also. Check. Scan.aura.com. Has it opened on anybody's phone? Got it, sir? Sir, can you tell your password? So the other day, I was invited by one of my friends to visit a forest. I told him, brother, I will come, but I will get my camera and come. He said, Anand, camera is not allowed. I said, okay, I'll get my mobile and come. He said, mobile is not allowed. I said, I'll get a drone and come. He said, not allowed. Then I said, you go. If I can't post something on Instagram, why should I come? So then he told, okay, I will go. But I told him, 100% I'll take your photo and send it to you. So he said, how can you take my photo without all these things? I told him, there is a new website that has come called skyfi.com. You can visit that site. You know that, now for example, I know that Ajitab ji is going to this particular location at this time on this date. I can hire a satellite and I can click his photo using satellite. This is where we are right now. God is watching. This is God. If you think that there is no drone, no camera, don't think that nobody is watching you. I may be the one who has used Sky-Fi to click your photo from a satellite which is thousands of kilometers above you. High resolution photos. The only flip side is each photo costs $335, which is roughly about 30,000 Indian rupees per photo. But still, a photo can be taken. So you cannot tell मुझे evidence नहीं मिल रहा है. And also, if you are lucky, you will get some previous photos which has already been taken, which you could probably use as an evidence. Google has used it. If you have a large area and you want to put a solar panel and you don't know where to put, ask Google where to put. It will tell you in that large area which area gets the highest sunlight. Because they know for the last 15 years how much of sunlight has fallen over that area. So this level of data analysis is happening. Just to tell you a very quick story, on 26/11/2008, Mr. Ramurthy ji was in room number 632 of Taj Hotel. Terrorists come there. They ask him, who are you? He says, I'm a teacher. They know that if he was a teacher like Anant Prabhu, he would not stay in a room that costs 40,000 rupees per night. They say, no, tell who you are. That time, the terrorist takes his phone, clicks a photo of Mr. Ramurthy, BlackBerry 2G connection, sends it to their command and control center, and after 10 minutes they get a response back telling that he is not a teacher, but he is one of the largest bank's chairman in India. Do you have, as police officers, that technology right now where I can click a picture of somebody and you can tell me who is that person? Yes or no? Number one. Number two, solve this equation for me, everybody. Very simple, very simple. Take your phones, Apple, Android, take your phones. Open this app called as Google Lens. Google Lens, one app is there on everybody's phone. Just click a picture of this, you will get the answer in 1 second. Take. I want to see who is the first person in the room to answer this for me. Google Lens, take a picture, you will get the answer. 4, exactly. Answer is 4. So you don't need to be a rocket scientist to solve this equation. Now the best problem is, when I was traveling, the customs guy caught me. And he told me that the watch that I was wearing has got gold in it. I told him, yes sir, it has got gold. But the person in front of me was wearing this watch. Why didn't you stop him? He said, what is there in this watch? There is no brand, there is no precious metal. Now same app, take a picture of this and tell me, how much does this simple looking watch cost? Please. Google Lens, take a picture and tell me. Let me see who is the first one in the room. 31,000, ma'am, I need 10 of such watches if it is 31,000. 31 lakhs, exactly. 31 lakhs is the cost of this Moser and CIE watch. Now, the point is, this is the app, Google Lens. If you don't have, scan the QR code and get the app on your phones. Now, you can do this with one glass. How many of you have got Ray-Ban Meta glasses? Anybody has here? Okay, I see 2 hands. Wonderful. Where you can interact with the digital world and the physical world at the same time. The other day what happened is I was walking and going in Kabban Park in Bangalore. I'm from Bangalore. 4 girls were coming. And I was looking at the girl wearing pink. So my friend told me, Anant, what, you're looking at that girl? I said, yeah. He said, are you going to talk to her? I said, no. He asked, why? I said, because she's 19 years old. She's too young for it. I can't talk to her. So he said, what do you mean she's too young? How do you know her age? Do you know her? Is she your student? I said, no. 2 students from Harvard University have worked on a project called Eye X-ray. If you connect that to your Meta glasses, anybody you look, it will tell you their name, age, address and phone number. Google. I'm not simply telling things. Google, Eye X-ray is the name of the project. It scraps the information from the internet of everybody and it gives the information. 2 students from Harvard University, Eye X-ray. Where is your privacy? I don't know. But we are living in an age where even if you give me shredded documents, I can reconstruct that entire document by using a tool called Unshredder. So even if evidence is shredded, I can get the original document back. So what is the only way to destroy an evidence now? Burn it. Exactly. Quick question once again to the audience. Ma'am, please stop me whenever. Yeah, please stop me. Quick question. How many of you are seeing this image as white and pink? Raise your hands. Raise your hands. White and pink. Very good. How many of you are seeing it as grey and teal or grey and green? Raise your hands. Perfect. Same image in the audience. Some are seeing it as white and pink. Now you tell me, how will you take a judgment on this? Same image. The judges are seeing it as white and pink and some are seeing it as grey and green. Now I will tell you, take your car key and press the unlock button. That is all I'm going to tell. If you saw it as white and pink, take your car key. There is a device called Flipper Zero. How many of you heard of it? If anybody asks you, which is the most dangerous device when it comes to cyber security, your answer should be Flipper Zero because it can hack almost anything. Okay. So I will take Flipper Zero. When you press the unlock button, I will record the signal, go to your car, unlock your car and take all the important documents that are there in your car and go without breaking the window. No glass broken, everything stolen. Evidence now. Okay, so we are living in this age where artificial intelligence is so important. But it started in 1950. It is not something that started yesterday, today. We are using ChatGPT from 2 years. The word AI was coined in 1956 at the Dartmouth conference, but it requires so much of computation that in 2012, NVIDIA came out with those chips which we could use AI, that is narrow intelligence, not the general intelligence. But I have been using general intelligence. A quick off-the-record question. How many of you are having a spouse who is irritating? In the sense, always asking you to message, always asking where are you, what are you doing? Everybody? I don't, I'm single. Huh? Everybody? Okay. My humble request to all of you, humble request. Not everybody, not everybody. There are good, lucky husbands and wives also. Okay. So, that is what Prajesh ji also told me. There are good people. Anyway, so now the question is, put this app called OpenClaw in your phone, in your laptops. OpenClaw. See, I told you we are in ANI, now we have come to AGI. OpenClaw. You don't have to reply on WhatsApp, it will reply on your behalf. And not even an iota of doubt your partner will get that it was not you, it was AI. This level of AI we have. In fact, when the Honorable Justice Ranjan sir had asked me to come here by the Judicial Academy, I got the mail. When I got the mail from Sir, Bharat sir, what I did is, I didn't open the mail. OpenClaw opened it. It saw my dates. It knew that I am free. It replied, sir, that I am coming. Trust me, it prepared my PPT. I did. Okay? I don't have, my room book, it asked me whether it has to be booked. But because the rooms were already done here, it didn't book, otherwise it would have booked my room also. And we call this as artificial general intelligence, where we are right. Okay? And it can do so many things. So the other day, I was at the National Judicial Academy. Next to me, Justice Anup Chitkara sir was there. And he gave me a judgment of his. This was his judgment, where bail was given to a pregnant lady in possession with narcotics. He told me, Anand, go through it. And within 1 minute, I told him, sir, wonderful judgment. He said, how did you read it so fast? All I did was, I went to ChatGPT. Okay. And there is an option here to upload from computer. And I uploaded the PDF. And I wrote, summarize the above in 10 bullet points. Even if it is a 500-page document, it will summarize it in 10 points or 20 points, whatever you ask it. Okay, that is not the question. The question is, a lot of people are telling me, it gives me wrong output. How many of you? Please raise your hands. Wrong output. Whatever you ask, it gives you all wrong. See, for example, here, this man asks AI, is this mushroom edible? AI says yes, and he dies. And AI tells, oh, you are right, it was poisonous. Would you like me to tell you more about poisonous mushrooms? He's already dead. Okay. So the point is, why AI is giving you wrong responses is because AI, even the Supreme Court has mentioned about fake cases and all that. That is because AI has got so much of information. Different. We want only legal information. For that, you should have a paid ChatGPT. How many of you have paid ChatGPT? Very nice. How much are you paying? 200. Okay, 299 that package. Go here to more, and there is something called Explore GPTs, and press Indian law. Okay, Indian law, and ask questions. I will change my name even if you get one wrong output from ChatGPT, because it is trained with accurate information. So right now, who is the richest or the strongest man in the world? The one who has access to the best algorithm. That's if you use outdated algorithms, you will not get. Even for that matter, earlier we used to tell phishing whenever it used to happen, check for spelling mistakes. Now cyber criminals are using AI to draft mails where there are no spelling mistakes, no errors of any sort for that matter. So whichever AI you use, okay. Now, next thing, I'm going a little faster. Now this is a problem. The classic old trolley problem. There is a train, brakes have failed, track splits into two. One track, one person has put here, track under repair and is doing some maintenance. Here 5 are there. You are here. Which way you will pull the lever? One person should go or 5? How many of you say 1? 1. Raise your hands. 1. How many of you say 5? No, brakes have failed. How many of you say 5? Raise your hands. Some of you have not raised your hands. Very dangerous people you are. Because you want the train to go like this, kill him, go back and kill the other 5? I don't know if that is the thing. Now this problem can come with the Tesla car. Tesla cars are already in India. If that same brakes have failed of Tesla and road splits into two, which way will the car go? We don't know. So if you know why that AI took the decision, it's called glass box AI. So my request to everybody is, don't use black box AI where you don't know why that decision was taken. You should use glass box AI. For that, let me give you some examples. Summarize a 500-page chart sheet into 5 pages. Which tool? For everything, don't use ChatGPT. For this, you have to use Claude. Next, generate a chronology of events from the pleadings. Which tool? For this, you use ChatGPT. Next, compare witness statements and identify contradictions. Which one? Notebook LLM. Anybody is using here Notebook LLM? Fantastic. Notebook LLM. It's from Google, sir. Notebook LLM it is. There's a mistake. Okay. Next. Extract all Supreme Court citations from written submissions. Which one? Perplexity. This is a tool. Anybody using? Very good. Very nice. Okay. Next. Summarize forensic reports in simple language. Because a lot of things, hash value, this, that, all so many things come. How to summarize it? ChatGPT again. Next. Convert lengthy hearings into searchable transcripts. Which one? Otter AI. Audio, you can make it into searchable audio. Amazing stuff. Otter AI. Last. Translate regional language. We have SUAS and SUPEs of the Supreme Court, but along with that you can use DeepL for foreign languages also, and prepare issue-wise case briefs before hearing. Notebook. I think it's Notebook LM, sir. Not Notebook LLM. Sorry. Notebook LM. Okay. Last. Verify suspicious videos. This is very important. Somebody comes with a video and tells, Anant, this is not me. This is deep fake. Now, how do you know whether the video is real or deep fake? Because everything looks so real now. Very simple. There is a new tool in the market. It's called Deepware. DEEPWARE. Upload the video there. It will tell you whether it is AI generated or real one. So simply a real video leaks and a person tries to hide under the guise of AI will not work anymore. Many of them have hid, but not anymore. Or you can use another tool called InVid. In is missing here. I mean, it's there, but you can't see InVid. And the last one, create FAQs, SOPs, court administration guides for registry staff. You can use Gemini. Okay. So now this is the point which a lot of people are asking me. Sir, I don't want my data to go out of my computer. Whatever tools you have told, if I put it there, data gets leaked. What should I do? Anybody has a solution for that? There are offline AIs, and these are the offline AIs. You can have your own laptop, put this into it. Don't ever connect your computer, internet or anything for that laptop. You will have AI running on your laptop without data going anywhere or without your chances of your data being leaked even 0.1%, because that computer is not connected to internet at all. These. Okay. We'll come to the questions. So I'll wind up just one last point. 2 girls called me for coffee. I went. And they started telling how both handsome ho, ye ho, ye ho. I didn't believe. I kept my phone on the table and went. How many of you have, again, iPhones? Answer. Perfect. Go to control center. Go to hearing. Enable live listen. Keep the phone on the table. Wear your AirPod. Go 50 meters away. You will be able to hear crystal clear what the people behind your back are talking. So the next time somebody keeps a phone on your table and goes, what do? Keep quiet? No. Talk good things about them, sir. Okay. And the same is there on Android as well. So on Android, you can go to accessibility, sound amplifier, open sound amplifier, and Android knows whenever you're talking about something, about somebody behind their back, you talk softly. So therefore, they've given to boost if you're unable to hear. Now I want mobile numbers of everybody. Will you give me? Will you give me a mobile number? Nobody wants to give them a mobile. Why? Am I so bad? That's all right. I have a small device with me called Septier. If I keep this in my pocket, I've not got it, you're lucky, and I just switch it on, in this room, how much ever people are there, everybody's mobile number will be captured by that device. So even if you don't give me, I don't care. I'll get it. It's called Septier IMSI Catcher. And, sorry, how many of you are believing this WhatsApp end-to-end messages are encrypted? Anybody? You believe? You believe? Oh my God. Okay. First of all, WhatsApp calls can be recorded. So don't think that important things I'll talk on WhatsApp because calls can't be recorded. Put this app on your phone called Cube ACR and record any WhatsApp calls that you want. Any. Without pressing record button also. Because it's automatic call recorder. Recorder starts. Second thing, don't click on unknown links because I want you to visit this website later, my.traxalon.com. By just clicking on that link, every detail about yours, including where you are, I can see it on my phone. You can also see it on your phone, including what is your battery percentage, which phone you are using, how many sensors are there, which is your phone, which is your browser, A to Z. my.traxalon.com. And I'm coming to the last part of today. I'm so sorry I have to rush. Yeah, this is my photo. Take your phones, everybody. Take your phones. Because everybody were talking about hash value and all that. Take your phones. Take my photo. Perfect. Good. Delete it later. Took my photo. Go to pic2map.com. PIC numerical 2 map.com. Upload that photo. You will get to know where the photo was taken. It will show you it is taken at the ITC hotel. It will tell you which camera was used, where was it taken, when was it taken. All this, we call this as metadata, the most crucial information when it comes to any digital evidence, whether it is photo or video. Data about data, metadata. Anybody, what is metadata of images and videos called as? It's called EXIF, E-X-I-F. And EXIF gives me this data. Here the location comes, which you are talking about, that app in which you are sending the photos. And I want to wind up my today's session by just telling one point. I was invited by a police. I went there to train their range. And after that, they asked, where do you want to go after this? I said, I want to go to Dandeli. Dandeli is a very beautiful place where you can do river rafting. I went to Dandeli. And when I went there, my father called me. He asked, where are you? I said, sir, father, I am at IG's house. I lied. Because in Dandeli, there is river and my father has got hydrophobia. If I go near water, he gets heart attack. So I told, I am at IG's house. He said, send me your location. I sent IG's house location. He said, I am your father, send me your live location. Now I knew that I will get caught. And then, now I am going to tell you why I am using Android phone. In Android, there is one app called as fake GPS. If I go to this app and put my location as IG's house, and any app, if I go and if I put what? Live location, they will get the location which I have put, not where I am. And this is how a lot of police officers during their night beat were doing that. Sitting at home, using fake GPS, sending that location of this place, that place, while they're at home. So therefore they started asking for photo proof. That also you can do it with ChatGPT, that is different. So therefore, my dear officers, right now we are talking about what? Forensics. But the most important branch that we should all pay attention to is anti-forensics. How the hash value will be misused. How the metadata will be misused. How a lot of things can be tampered. So you need to check whether that phone had a fake GPS app and through that the EXIF was generated or not. For instance, I have this camera which is called infrared camera. If I just take a picture of the pin that you have written, I will get to know what you have typed. Now you may think all buttons are yellow, but it is very simple. Go to ChatGPT and ask, tell me in which order the keys were pressed. It will tell you it was 1, 2, 3, 4, 5. Okay, so I don't want to take too much of time. AI may assist justice, but it must never replace wisdom. Injustice at the speed of light is still injustice. If you have any questions, ask ChatGPT. Okay? Thank you. Thank you very much. These are my details. And thank you, sir. And thank you, everybody, for having me here. Jai Hind. God bless. And these are my details.
Thank you very much, Prabhuji, for showing us horror movie of our own lives. Now I request our other resource person, Mr. Pranavji, to go in.
Hello. Thank you, leadership. My lords on the dais, my lords of the dais, distinguished participants, ladies and gentlemen. We have just had a very fascinating story on what technology can do and what technology can, how technology can be so deceiving. Because for the last 2 days, what we have been witnessing is the scope of technology in the courts. And now in the last, my preceding speaker has very easily dismantled all the concepts of infallibility which has been created for the last 2 days. And with this, with the permission of the chair, I'll start my presentation with a story of a global injustice which almost got perpetrated because of the infallibility of technology which was perceived. It's a real story from United Kingdom, from England. A very famous story on which a number of web series, movies, and serials, they have been enacted. In around 2000, all the post office in England, they adopted a new software which was known as Horizon software. That was an accounting software. Immediately when the software was adopted, after 5 years or 10 years, a number of accounting errors started coming in. And the postmasters who were handling them, around 900 of them, not one or two, 900 of the postmasters, they were prosecuted. They were prosecuted for fraud, for committing defalcation of money, running into billions of pounds. 256, around 250 people were jailed. and some committed suicide. Some people also, their lives were ruined. But there was a person named as Ellen Bates who took up the fight on behalf of all these postmasters. And then there was the expertise of Lord Justice Fraser, a judge of England and Wales High Court. The technical expertise of the Honourable Judge of the England and Wales High Court, he produced a beautiful judgment, a judgment which is titled as Ellen Bates versus the Post Office, 2019, England Wales High Court, 3408 Queen's Bench. This judgment tells us that technology is not infallible. Even if there is digital technology, it has to be taken with a pinch of salt. With this background, and with the important information and fascinating information that we have just received, I will take up the practical challenges, the challenges which will look into a sort of criticism, but it is not a criticism, but it's a mirror check as to how all the app, all the e-Saksh and all the technology that we are talking about, how it is performing in the courts. And that is why we are all concerned, because it is the court is the last person, as one of the speakers have already told. It is the last receptor. And every institution, be it the police, the prosecution, everybody is working for producing it for the courts. I will take up the issues of challenges. I will also take up the issues of the roadmap. I will take up issues of how to have the capacity building from the perspective of a court. This may come across as a dry subject after such a fascinating speaker, but then I'll seek your ears. The very first point is, everybody has talked about interoperability of the system, and they have talked about the 5 pillars. 2 years have already elapsed. We are into the second year, and still we are talking about the integration of the system. And why I'm saying so? The law does not demand excuses. The law will not excuse because 2 systems are not integrated. We will not have a judgment coming out of an honorable court or of a trial court that since the systems were not interacting with each other, so he is absolved. The law will demand real evidence. The law will demand the technical requirements. And let me talk about the first app, e-Saksh app. For the last 2 days, so much has been said upon it. And I'll take up a very basic question. There are around, as per the data of SCRB, 30,036 videos that have been uploaded on it. Agreed. There are 22,000 investigating officers who have already been registered. Agreed. Now what happens to those videos? Section 105 mandates, as Honorable Leadership has already said, it is a must provision. Section 185, it talks about search and seizure by an investigating officer of SHO. That is a must provision. So what happens to all these videos which are lying stored? Because we are not integrated with it. Will the trial court stop looking at the videos? I'm talking about the practical consideration. The videos are there. It is an evidence. And under the new laws, it is a document. It's not electronic evidence, it's a pure document. So my first question is, under section 230 of the BNSS, corresponding to section 207 of the CRPC, every accused person is entitled to a copy of the document on which the prosecution relies. It is must. The Honorable Supreme Court, as Leadership has pointed out, the judgment of P. Gopalakrishnan alias Dilip versus State of Kerala, 2020, Volume 9, SCC, page 161. And prior to that, Tarun Tyagi versus CBI, 2017, Volume 4, SCC, page number 490, made it explicitly clear that if there is electronic evidence, a copy of it, and not a simple copy, not an ordinary cut copy paste, but a cloned copy of that has to be provided to the accused mandatorily. Where is that mandatory provision? Where? Because today, the court are yet to get the document. When the court itself is not getting the document, how will the court supply that document to the accused person? This is the first question. The second question is, under the new laws, the onus lies on the police explicitly. Earlier it was implied, now it is explicit. to produce as many copies of police papers as there are total number of accused. So I ask a question. The videos are lying there, and the director of the NIC, the learned director of the NIC, he said that steps are being taken that the other actors like accused, witnesses, etc., they will be formed apart. So what happens to those trials which are pending today? Will we say to the accused person, since in your case the app is yet to be developed, so you will not get police papers. You will be deprived of that. And will our constitutional courts accept that? Will the trial court accept that? That is a challenge. There lies the question. What happens to those trials? Because we are already 2 years into the provisions. This is a question. We move to the next part, again in the e-Saksh, and I'm talking about the practical experiences of many of the trial court judges of whom I have interacted on this subject. You know what is happening? The investigating officers, the police officers, sadly to say, they go there, they record the evidence as it is. And there are instances, what happens is that IO who goes there, he takes up the cell phone, he records it through e-Saksh app, and then he uploads it. What is the relevance? What is the value of such an evidence? Yes, we are saying that the investigating officers, the prosecutors, they are being trained. But is the question of being trained will be allowed over the legal requirements? What will happen to the evidence which has been produced by an untrained investigating officer? What happens to those cases? These are questions that cannot be left open. We have to answer it. This is the first challenge. I don't know of a solution. But the next challenges that are before us, ahead of us, I will also try to give some of the perceived answers that I believe. And the second one forms the core of the entire presentation. It is about the challenge of digital, how do we interpret the digital evidence? There is multiplicity of digital evidence, WhatsApp chat, everything is there on. Every person moving around with a cell phone is having some sort of digital evidence. How do we translate it into reality? I was told that everybody now knows that there is a requirement of a certificate when there is a secondary evidence. But yes, let me remind you, which was reminded yesterday by Honorable Justice Joymala Bagchi, sir, that now there is not requirement of one certificate. Be absolutely clear. There is requirement of 2 certificates. It has been made explicit in Pune Bar Association versus Union of India, writ petition number civil 599 of 2026, decided on 22nd of May 2026. It's a recent judgment. And among the points that Honorable Lordship yesterday told, the second important point was the constitutionality of second certificate was challenged, which was upheld. And it was held that it is a mandatory provision. Wherever you are giving first certificate, you have to give a second expert certificate. The only thing that was diluted is this second certificate need not be given by Ministry of Information and Technology labeled expert, but it can be by any ordinary expert. That is the dilution that has been done for all of us. And here I am reminded about Lord Justice MR's famous dictum in Taylor versus Taylor, which has been quoted by Honorable Supreme Court in n number of judgments, in almost every judgment on electronic evidence, that if the law mandates a particular thing to be done in a particular way, it has to be done in that way and in no other way. That means the technical requirements which are there explicitly mentioned in section 63(4) has to be followed by the prosecutor, the police, howsoever grave the crime may be. You cannot take excuse that, see, I don't have second certificate, still you go ahead. Now coming to this certification part, there is another very important point which I believe everybody must understand is contemporaneous certificate. Earlier it was delivered by Honorable Supreme Court, that it was part of judgment. Now it is part of law. That every time when an electronic evidence changes its hand, every step, you need to have fresh certification. And if that is missing, what will be the consequence? Could be a question. If a certificate is incomplete, what will be the consequences? And that has also been answered by the Honorable Supreme Court of India. That if a certificate is incomplete, Smriti Madan Kansagra is a case law, 2021, volume 20, SCC, page number 421. That if a certificate is incomplete or it is a partial certificate, it means no certificate. So the challenge before us is that it is not only about the certification, it's about a complete certification that needs to be given to the courts. If you want your electronic evidence to be presented and to be admissible. And here comes the second question. Most of the prosecutors, investigators, and some of us as well, believe that the moment the certificate is given to us, that electronic evidence, now we'll have to accept it as it is. But the answer is no. You don't have to. It's just the threshold. A certificate along with an electronic evidence in case of secondary electronic evidence only means that this is an evidence which now you can read. This doesn't mean that you have to accept as it is whatever the contents of the electronic recorder. Then what is the answer? The answer earlier was in the judgments of Honorable Supreme Court, started with Anwar PV versus PK Bashir, the very celebrated judgment, and now it has been explicitly made part of the BNSS. Section 193, subclause 3, more subclause 1, point I, 193.3.1I. It says that at every step there has to be a chain of custody. That is one step. And what about the other? The other is mentioned in Schedule 1 and Schedule 2 of the Bharatiya Saksha Adhiniyam. And that is the hash value, which we also call the fingerprint. How to calculate it? It's very simple. It's very simple. If you have a photograph, if you have a video, you can have n number of websites. You just need to give a link to it. It will immediately create a value. And there are numerous mathematical values. And my expert will correct me if I'm wrong. You cannot reconstruct an audio or a video from that hash value. Hash value can give only one time number. Means you cannot reconstruct an audio or a video from a hash value. I hope I'm correct. So that is contemporaneous certificate.
Sir, can I just add one point? A lot of people get confused between encryption and hash. So now, for example, if you have a 1 GB file, which you want to send it on WhatsApp, it encrypts it and it sends it there so that nobody can read it in between, and only the person who has got the decryption key can decrypt it. So the size of that file will be 1 GB only, or maybe a little more. But when you're hashing something, even if it is a 1 GB file, the hash value will just be one line. Even if it is a 1 TB file, the hash value will be just one line. It is only to check whether that file has been tampered or not. You will not get the original document back no matter what you do from that one line that you have got of that particular file. So therefore, we don't have the term called dehash. We only have encryption and decryption. Hash, that's all. You just get a value. But one mistake which everybody does is when they take the hash value, they don't mention which algorithm was used for taking the hash value. Whether it was SHA1, SHA3, SHA256, SHA512, you just give the hash value there. We will not get to know, looking at the hash value, which algorithm was used. So therefore, we have to mention very clearly which was the algorithm used and the hash value.
Sir, on that algorithm part, there is a specific requirement now under Bharatiya Saksha Adhiniyam that has to be, there is a box of SHA1, SHA256, MD1, MD5, all these. In fact, that has to be clicked. So I request all the prosecutors, the police officers, that when you are submitting the certificate, please ensure, as Anand sir has said, that the exact box also needs to be clicked, because I have already told that in Smriti Kansagra case, the Honorable Supreme Court has said that an incomplete certificate is no certificate. So that is another point. Now, I will not dwell much upon it. The third challenge that we believe in electronic evidence is, which now the investigators will come, because we have section 105, 185, 176, where it always talks about electronic evidence, is if an electronic device is obtained from an accused person, can a person be forced to disclose his password? If an investigating officer comes before you and says that that accused person is not giving his password, he's having an Apple phone which is we cannot crack, can you force him? This is a question which was answered by two of the Honorable High Courts in India. And Honorable Karnataka High Court in Virender Khanna versus State of Karnataka and P. Gopalakrishnan alias Dilip versus State of Kerala. And they have answered in affirmative. They have said that yes, an accused person can be forced to part with his password. These are two Honorable High Court judgments. There is no conclusive Honorable judgment of Honorable Supreme Court of India. As far as Delhi High Court is concerned, there was one line single reference in Hitesh Modi versus CBI that an accused cannot be forced to part with his password. So this is a question. There are two judgments on one side. There is one judgment on one side. The Honorable Karnataka High Court discussed all the constitutional bench judgments, 11-judge bench, and it concluded that one has to give password. Now the third important point that I immediately want to take up is actual physical handling of the digital evidence in the court. Almost all of us who have been in the trial court and who have seen electronic evidence, they have seen the compact discs being, tied up with the CD, tied up with the records. And you'll be surprised that this compact disc has been tied from the middle and it cannot be used in any sense. You have been given a pen drive in a simple way which is hanging from a record, which you don't know, which can immediately be erased. You have all these kinds of shortcomings, and apart from that, all those who are trial court judges who are handling excise matters, there may be 10,000 plus matters, even more than that, where the only evidence is the breath analyzer report. And the breath analyzer report is printed on a paper, of which the printing of which gets immediately vanished after 4 months, 5 months, or 6 months. As a registrar list, I can see even in bail matters, when a photocopy of that is presented, that is almost a blank photocopy because the data is already erased. Now I shudder to think what will happen when after 1 year, 1.5 years, when the trial will actually start, what will be the evidence before the court? The record which is printed on it is already cleaned. You have a blank sheet of paper. So there needs care, there has to be some sort of infrastructure where you are going to save, and that infrastructure is to be immediately created, where you have to save the electronic records, because electronic record, as Prabhu sir and everybody knows, is so fragile that even if for a moment that CD or a pen drive is left, it can immediately, the contents can be changed. And imagine a pen drive contains the CCTV of a murder case and the contents have been deleted. And that is the evidence before you. What happens? There is no copy left. So these are some of the concerns which concerns the physical infrastructure of that. Now coming to the next challenge, immediately I'll take up, that is about human resources. Yes, everybody right from the judges to the prosecutors to the police officers, they needs to be adequately trained about the technical requirements, because for the first time they are seeing electronic evidence coming up in such a big way. People, even lawyers, everyone, they are used to seeing documents as the primary evidence. Documents. Here what we are having is electronic evidence, and the nature, though it is defined as document, but the nature of a paper and electronic evidence is way, way, way different. So we need to tell our investigators, prosecutors, ourselves, that we need to have a special expertise. And I may say, like we have Modi's medical jurisprudence as a standard textbook in all the law libraries, we can also have Stephen Mason's electronic evidence in all the libraries. That is an urgent requirement, so that if each one of us who knows contusion, abrasion, and concussion, they must also know what is hash value, what is date stamp, time stamp, and hashing. These are the challenges, and in this entire exercise, we are forgetting one of the most important pillars, that is the defense lawyer. Our experience says that defense lawyers have absolutely almost no idea of electronic evidence in most of the places. Now, how will that accused be protected? How will he cross-examine him? So there is a requirement. We need to have there has to have some sort of training program for these defense lawyers as well, so that the right under Article 21 is also legally protected. Apart from these challenges, we talked about infrastructural challenges. I will not speak on the infrastructural challenges because the Honorable High Court and the state government and the central government, it is taking care of. It is going to provide us with the laptops or with the necessary infrastructure. So, with these words, as far as roadmap is concerned, we'll take up some other day. But again, I return back to the last point which I made is the Horizon software case. It was not a story of despair. the story told us that if there is resilience, the story told us if that we are having the expertise, we can also undo the injustice that has been done. And I believe with the adequate amount of training on BNSS, BNS and BSA, we, all the integral part of the criminal justice system, we could take up our state, we can take our state at that high level, and we can also achieve the instrumentality, or we can achieve the highest ideals of justice using technology and all other tools that are being provided to us. Thank you so much. Thank you.
Thank you very much, Pranav Shankarji. I request my brother Harish to give the concluding remarks of this session.
A very good afternoon to all who are present here on the dais and off the dais. Honorable Mr. Justice R.R. Prasad, Judge cum JD 2 and Chairman of the Bihar Judicial Academy, all my sisters and brother judges, my esteemed judicial officers, the officers of the prosecution, and all the dignitaries as well as ladies and gentlemen. As we conclude today's fifth and final technical session, it's my privilege to express my sincere gratitude and sincere appreciation to our distinguished resource person, Sri Ajitav Kumar, ADG, SCRB, Dr. Anand Prabhuji, distinguished academician and internationally recognized expert, Mr. Prabhnav Shankar, the Joint Registrar List and Computer, for sharing with us their valuable insights, practical experiences, and thoughtful perspectives on the challenges of digital adoption, strengthening infrastructure, capacity building, and uniform implementation of technology across our judicial system. As our sister, Honorable Justice G. Anupma Chakravarti rightly observed, while inaugurating this session, the new criminal laws call not merely for legislative reforms, but for a transformation in our system, our process, and most importantly, our institutional mindset. Today's discussions have reinforced that vision. Our resource persons cumulatively have reflected upon the challenges before us, uneven digital infrastructure, connectivity issues, cyber security concerns, interoperability of systems, and the need for continuous training and technical support. Yet, we have also been reminded that these challenges are not barriers. They are opportunities to build a more resilient, efficient, and citizen-centric justice delivery system. What we have learned today from the challenges and solution on the topic that successful digital transformation depends not only on technology, but on people. Infrastructure can be created and software can be deployed, but lasting challenges comes through continuous capacity building, collaboration among institutions, and a willingness to embrace innovations while remaining firmly anchored to the fundamental principles of fairness, transparency, and judicial independence. As we move forward, let us remember that success of digital transformation will not be measured by the number of devices installed or platform introduced. Its true measure will be whether it enables justice to be delivered more efficiently, more transparently, and above all, more accessibility to every citizen. With these thoughts, I once again thank our esteemed speakers and all the participants for their valuable contributions. I am confident that today's deliberation will translate into meaningful action and strengthen our collective endeavor towards building a digitally empowered and future-ready judiciary. With all these words, I once again thanks to my resource persons, and I give this, and I invite the sister.
Thank you very much, Brother Harish. With the permission of the chairman, I would like to conclude the proceedings. Thank you.
I request the organizers to kindly get the dais ready for the concluding session. Over the course of the last 2 days, we have deliberated extensively upon legislative reforms, institutional coordination, statutory timelines, technological innovations in capacity building for the effective implementation of the new criminal laws. The valuable ideas, recommendations, and practical insights that have emerged from these deliberations will undoubtedly contribute towards more efficient, transparent, and citizen-centric administration of criminal justice across the state of Bihar. We will now commence with the concluding session of this conference. For this session, it is my honor to most respectfully invite Honorable Mr. Justice Bibek Chaudhary, Judge, Patna High Court, to kindly grace the dais. I now request Shri Bharat Bhushan Bhasin, Director, Bihar Judicial Academy, to felicitate Honorable Mr. Justice Vivek Chaudhary, Judge, Patna High Court, with a planter and memento. May I now most respectfully invite Honorable Mr. Justice Vivek Chaudhary, Judge, Patna High Court, to deliver the closing remarks and outline the way forward emerging from this conference. Lordship, please.
Honorable JD2 of Patna High Court, Bihar, and the Chairman of the Bihar Judicial Academy, my esteemed senior brother, Justice Mohit Shah, my esteemed brothers and colleagues, the members from Judicial Service, the police officers. Now, it is absolutely a difficult task for me to sum up a 5 days program within few minutes. And secondly, the way today's program went on, and it was so enchanting, so fascinating, and on certain subjects I am absolutely unaware, that it is really difficult to say something about the takeaways from these sessions as well as the way forward. But when I am entrusted with the duty, I shall try only. One thing is clear, that yesterday's inaugural program set out the tone of these 2 days program, and what should be our way of discussion, manner of discussion, in which path we should proceed. That has been fully decided in the inaugural session. In the inaugural session, though I am directed to, or I am instructed to summarize this session, but I think that a few words is required to be said. In the inaugural session, the Honorable Judges from the Supreme Court, our respected Honorable Chief Justice, and other dignitaries said about the mission and vision of new criminal laws, that is BNSS, BNS and BSA. But there was only one lecture that practically enthralled me and fascinated me, where the philosophy behind the change was just touched upon by our Honorable Chairman of the Judicial Academy, Justice R.R. Prasad. His Lordship in his speech, said two names and only touched the basic philosophy behind promulgation or behind change of the old law with the new. They are great philosophers, legal philosophers of England, Jeremy Bentham and subsequently Roscoe Pound. So, practically, I say that my younger brothers from the judicial fraternity, you may know, but for your daily work, it is not required to know the contribution of Jeremy Bentham and Roscoe Pound. Bentham defined as the fundamental axiom of his philosophy the principle that it is the greatest happiness of greatest number that is the measure of right and wrong. So in a society where the greatest number of people stay with happiness, there will be greatest good, and the criminal law should strive to achieve this. Secondly, the Roscoe Pound was the propounder of jurisprudential concept of social engineering theory. He views law as a dynamic tool to reconcile competing interests in society, maximizing benefit and minimizing friction or tussle or enmity. In criminal law, this theory provides the foundational justification for why the state criminalizes the acts, detailing a balance between individual liberty and public security. The interaction between Roscoe Pound's framework and criminal law can be understood across the core interest classifications, and their individual interest, public interest, and social interest. So we are confronting regularly with individual interest and the state interest, public community interest and the state interest, and the social interest and the state interest. As a result of which, different kind of offences are coming. So how to deal? We have heard throughout 2 days that the BNS, BNSS and BSA introduced human approach, introduced Nyaya in place of Danda, that is penal. What is Nyaya? Nyaya is fairness, righteousness, equity, and justification of dispensation of justice with fairness. Previously, main purpose was to give penalty, to give punishment. Now, it is not punishment. It is the human good by way of deterring the criminals, rehabilitating them, and make them a responsible citizen in future. This is the paradigm shift which was only touched upon by our Honorable Chairman of the Bihar Judicial Academy. However, I was intending, immediately I heard it, that I shall say a few words about this. Sir, with your permission, now I am taking up today's sessions just in few words. What are the takeaways? First, our first session is interagency coordination, investigation to conclusion of trial. Now in investigation you have heard from yesterday that there were certain changes. What were the changes? When in a particular section application is written, complaint is not written, whether the magistrate is empowered to send the complaint under the provision of 181 or 187, whether a person, whether a police officer, investigating officer can take the help of a magistrate who is not in the jurisdiction, who is not sitting in the jurisdiction or outside the who is holding court outside the jurisdiction, for recording 164 statement of a victim or an accused, etc., etc. But this session concerns the working relationship between the four principal actors in criminal case. They are, firstly, court, investigating police officer or investigating agency, forensic science laboratories, the prosecution, and the BNSS introduces specific chain of statutory timelines running from the first information through to judgment. These are first preliminary inquiry in respect of cases, in respect of offences up to 7 years, 14 days statutory timeline. Provision is section 173, subsection 3 of the BNSS. Forensic expert visit, it is mandatory in case of cases where the punishment is 7 years and more. That is 176(3) of the BNSS. Now, crime scene crime scene to be recorded by way of videography, offences punishable 7 years or more, notified within a period of 5 years by the state government in this regard. This is where we have rolled out the new criminal law. It is the second year, so 3 more years are left. After that, it is obligatory that videography is required to be done. We shall ask for videography of the crime scene. Thirdly, investigation in specific sexual offences, which is stated in BNSS 64 to 71, as well as POCSO Act 4, 6 and 8. 2 months investigation is to be completed. By 2 months from the date of lodging information. That is section 193, subsection 2 of the BNSS. Victim of the informant to be updated on investigation procedure every 90 days. Further investigation, one case has already been sent to the court, 90 days from the grant of court's permission. Section 193, subsection 9 of the BNS. Supply of documents to the accused oblique victim, it is 14 days. Section 230 BNSS. Committal of case for trial, 90 days from the date of cognizance. Section 232 of the BNS. Discharge application, 60 days from the order of committal. Now you see that in the courts of the additional district judges and the principal district judges, a discharge petition is pending for years and years together to be decided. And thereafter, it is decided after a lapse of say 5 years, and then it comes to the High Court by either of the parties challenging the discharge, order of discharge or refusal of discharge order. It will again go on for 5 years. So it takes 10 years at least to get the fruit of it. That is not the purpose of criminal trial. Speedy trial is the sine qua non of criminal trial, and that has been stated aptly by the Honorable Justice Shoni Srivastav as a chairman when she repeatedly said, delay, delay, delay. Delay is the main blockade against the criminal administration of justice. Thereafter, framing of charge, 60 days from the date of hearing of the charge. Examination of the witnesses, day to day. Yes, I have passed an order that the witnesses are to be examined daily. I know that there are practical difficulties, but this order was passed by me in order to embolden you, in order to embolden your hand, because of the fact that you are the person, you can ask the prosecution, you can force the prosecution and the investigating agency to produce the evidences within a shortest possible time so that the trial of the case cannot be delayed. Number, pronouncement of judgment 30 days and the uploading of judgment in the portal 7 days from the date of the pronouncement of the judgments. So, one thing I should say, that none of these deadlines can be met in isolation. The forensic timeline under section 176 subsection 3 depends in Bihar having notified the provision and built the requisite FSL capacity, since implementation is expressly left to the state notification within a 5-year window. The 90-day committal and 60-day charge framing timelines depend on FSL report and charge sheet reaching the court in usable form in the first place. In practice, delay tends to concentrate at these handover points rather than within the single agency's own work. Forensic reports awaited by the prosecution before the charge sheet can be finalized. Charge sheets awaited by the court before the charges can be framed, and the records awaited by the prosecution before the evidence can be laid. Now, in session 2, it was on e-Saksha and treatment of electronic evidence under the BSA. I have divided this topic into 3 subheads. First is e-Saksha and treatment of electronic evidence. e-Saksha is the mobile application. It is a mobile application developed for use by investigating officers and forensic teams to capture and upload evidence, that is the photographs, videos and other materials gathered And even in CRPC also, we are taking the evidence of CCTV footage, we are taking the evidence of videos, and how these are to be taken. You know that in CRPC, Evidence Act is applicable, so compliance of Section 65B for application of secondary evidence, it is there. But now, the electronic evidence has been treated as primary evidence. So it is when it is a primary evidence, some sort of protection has been stated, or those protection was introduced in BSA, and therefore there was some preconditions that crime scene examination or the videography of crime scene, videography, seizure list, videography of victims' statement, accused statement, etc. These are to be time-stamped, geotagged, and traceable. So, explanation 5 of section 57 widens the definition of a document to expressly include electronic and digital records, placing them on the same footing as paper document rather than as a separate lesser category of requiring special justification. Section 2B concerns about case information system, CIS. CIS is the case management software. I am telling you, CIS is the case management software, and until and unless a case is uploaded in CIS, case information system, you will not be able to upload your orders, and even you cannot bring out the daily cause list. The main blockage here is that practically we are uploading present case records in CIS system in online process, but so far as the old case records are concerned, until and unless old case records are uploaded in the CIS system, you are not in a position to fully publish your daily cause list or daily diary. And the condition is absolutely gloomy in the state of Bihar. Total pendency in the High Court in respect of the old cases is 2,21,145, which are yet to be uploaded in the CIS system. These are our old cases. Total pendency in the district courts is 42,115, out of which criminal cases are 3,19,873. So, this means, and amongst this, I am telling you, many of the cases, or most of the cases are traffic challan cases. So, if those are disposed of, you can upload it as a disposed of data and eliminate it, and thereafter pending cases. At least, if all the judicial officers take care to give half an hour time, at least daily, with the help of your court officers, 50 old cases can be uploaded, and until and unless it is uploaded, there will not be full implementation, full rollout of CIS system, and FAT to say CIS 2.0. There are lots of data, we should not say anything. And third point in item number 2C is e-summons and Nyasruti. E-summons refers to service of summons on accused persons, witnesses or parties through electronic means. So far as the e-summons is concerned, I do not know, I do not have the data whether e-summons are issued by the district judiciary or not. But in our court, we are passing order regularly, admitting an appeal or revision to directing the learned advocate for the petitioner to file requisites for issuance of notice by way of registered speed post as well as through ordinary through court. So it means that we have not been able to even to issue summons in the High Court also. Nyasruti, as demonstrated in this session, is a platform intended to facilitate audio-video communication with and recording of statements or testimony from victims and witnesses, and reducing the need for repeated physical awareness, which is particularly relevant for vulnerable witnesses and for witnesses located far from the trial court. For both tools, the question that ordinarily distinguishes a successful from a token rollout is the extent of actual use across the state, particularly in the rural and subdivisional courts where connectivity and digital familiarity are more limited as opposed to availability of the tool in principle. Now, with regard to the digital infrastructure and statewide action plan, practically don't say don't think anything, but don't take it, take me in a miss. Hearing the lecture of Mr. Ajitav Kumar, it seems to me that he justifies the failure of police department to roll out the software system. He only stated what are the defects and what are the backlogs. But immediately we were surprised and enthralled by the lecture of our beloved professor. Professor, you have showed us and you have opened a new vista before our eyes, where I shall request our chairman of the Judicial Academy to organize a full-day seminar by you for the High Court judges first and thereafter judicial officers. Please, sir, kindly. But ultimately, our takeaway and our what is the how we should proceed forward, we have found the difficulties. Now it is our duty, and it is absolutely, it is the duty of all of us, all the judicial officers, and it is the concerted effort that wherever there are glitches, there are problems, we must go ahead and we we will not consider those problems, and we must complete the CIGS rollout within the stipulated period of 5 years, 3 years of which are still remaining. Thank you. Thank you for giving me the opportunity.
Thank you, my Lord, for those inspiring and forward-looking observations. May I now request Shri Bharat Bhushan Bhasin, Director, Bihar Judicial Academy, to deliver the formal vote of thanks.
Honorable dignitaries of the dais, distinguished participants present in this auditorium, as well as those who have joined us online. Ladies and gentlemen, good afternoon. As we arrive at the close of this remarkable two-day state-level conference on new criminal laws, it's my privilege on behalf of Bihar Judicial Academy and on behalf of BIPARD to offer this vote of thanks. Over the past 2 days, we have not merely participated in a conference, we have collectively reaffirmed our shared constitutional commitment to the ensuring that transformative vision embodied in Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshya Adhiniyam is translated into an efficient, accessible, and technology-enabled criminal justice system. I respectfully convey our profound gratitude to Shri Samrat Chaudhary, Honorable Chief Minister Bihar, whose gracious presence greatly enriched this conference. His inspiring address reaffirmed the state's unwavering commitment towards strengthening institutions, modernizing criminal justice administration, and fostering seamless coordination amongst all stakeholders. I respectfully express our profound gratitude to Honorable Mr. Justice N. Koteshwar Singh, Judge, Supreme Court of India. His Lordship's illuminating address has reminded us that success of new criminal laws ultimately depends not merely upon statutory changes, but upon institutional commitment, seamless coordination, and faithful adherence to constitutional values in day-to-day administration of justice. We express our heartfelt gratitude to Honorable Mr. Justice Joy Malia Bagchi, Judge, Supreme Court of India. His Lordship's insightful observations have greatly enriched our understanding of philosophy underlying the new criminal laws and the imperative of ensuring timely, fair, and victim-centric criminal justice through effective implementation. We most respectfully thank Honorable Mrs. Justice Meenakshi Madan Rai, Honorable the Chief Justice Patna High Court. Her Ladyship's august presence and inspiring words have been a source of great encouragement. Her Ladyship's emphasis on an efficient, responsive, and citizen-centric justice system will continue to inspire our collective endeavor. We thank your Ladyship for guiding and motivating us to successfully organize this conference. We respectfully thank Shri Roger Randeep Rai, esteemed spouse of Honorable the Chief Justice, for gracing this occasion with his valuable presence. With utmost respect, I express our heartfelt gratitude to Honorable Mr. Justice Rajiv Ranjan Prasad, Judge, Supreme Court of India, come JAD2, come. I'm sorry. Judge Patna High Court, come JAD2, and Honorable Chairman, Bihar Judicial Academy. It is under His Lordship's visionary leadership, constant encouragement, and unwavering commitment that this significant initiative has taken place. His Lordship's foresight in bringing together every important stakeholder of the criminal justice administration has made this conference a truly meaningful platform for dialogue, reflection, and institutional cooperation. I take this opportunity to express our heartfelt thanks to honorable members of Board of Governors, Bihar Judicial Academy, for their lordships' guidance, motivation, and unwavering support in organizing this conference and in our all endeavors towards judicial education. We feel deeply obliged to Honorable Mr. Justice Mohit Kumar Shah, Judge, Patna High Court, come Honorable Member, Board of Governors, Bihar Judicial Academy. His Lordships so ably chaired the opening technical session on the transformative changes introduced by BNSS, and BSA. His Lordship's stewardship set the academic tone for the conference and remarkable clarity with judicial insight. We feel indebted to Honorable Mr. Justice Vivek Chaudhary, Judge, Patna High Court, for inspiring concluding address which brought together the essence of 2 days of thoughtful deliberations. His Lordship's vision of an efficient, coordinated, technologically empowered, and citizen-centric criminal justice system has provided a fitting conclusion to this significant conference and a compelling roadmap for the future. We express our special gratitude to Honorable Mr. Justice Anil Kumar Sinha, Judge, Patna High Court. His Lordship's concluding address at the end of the first day's proceedings beautifully distilled the key lessons emerging from the day's deliberations. His Lordship's reflections not only consolidated the discussions but also provided a thoughtful bridge to the sessions of the second day. We sincerely thank Honorable Mr. Justice Sandeep Kumar, Judge, Patna High Court, for presiding over the session devoted to statutory timelines in investigation, filing of charge sheets and trials. His Lordship's guidance underscored the importance of timely justice as an indispensable component of the rule of law. Our heartfelt gratitude is also extended to Honorable Srimati Justice G. Anupama Chakravarti, Judge, Patna High Court, come Honorable Member, Board of Governors, Bihar Judicial Academy, for gracefully chairing the final technical session on digital adaptation, infrastructure development, and capacity building. Her Ladyship's guidance underscored the need to embrace technology while strengthening institutional capacities. We are equally grateful to Honorable Mr. Justice Harish Kumar, Judge, Patna High Court, come Honorable Member, Board of Governors, Bihar Judicial Academy, for his Lordship's insightful remarks in the fifth technical session. We are equally thankful to Honorable Mr. Justice Arun Kumar Jha, Judge, Patna High Court. His Lordship's thoughtful observations enriched the deliberations and highlighted the practical dimensions of streamlining criminal justice procedures. We express our gratitude to Honorable Mr. Justice Dr. Anshuman, Judge, Patna High Court, for his Lordship's enriching discussion, enlightening us for more effective execution of procedural statutes. We express our sincere thanks to Honorable Mr. Justice Alok Kumar Sinha, Judge, Patna High Court, for presiding over the session devoted to technology-driven justice delivery. His Lordship's guidance reflected the growing importance of digital transformation in the criminal justice system. We are equally thankful to Honorable Mr. Justice Saurendra Pandey, Judge, Patna High Court, for his Lordship's rational and guiding observations in the fourth technical session. We respectfully thank Honorable Srimati Justice Soni Srivastava, Judge, Patna High Court. Her Ladyship remarkably chaired the deliberations on strengthening interagency coordination from investigation to conclusion of the trial. We are equally grateful to Honorable Mr. Justice Ajit Kumar, Judge Patna High Court, for his Lordship's valuable remarks. We express our profound gratitude to Honorable Mr. Justice Ibrahim Matthew, former Judge of Kerala High Court, for his Lordship's comprehensive speech encapsulating the nuances of new criminal laws. We equally express our deepest gratitude to all the Honorable Judges of Patna High Court who have enhanced the spectrum of this conference by their gracious and active participation. Their Lordship's contribution throughout these 2 days reflects their Lordship's abiding commitment to strengthening the administration of criminal justice and ensuring effective implementation of the new legislative framework. We respectfully thank esteemed spouses of Honorable Judges of Patna High Court for adding value to this consultation with their graceful presence. We deeply express our thanks to esteemed speakers, Shri Neeraj Tiwari, Dr. Ravikant Deo, Shrimati K.S. Anupam, Shri P. Kanal, IG Police, Shri Subhash Chandra Sharma, Director Administration, Bihar Judicial Academy, Shri Ranjan Kumar, Joint Director, IT NIC, Shri Ranjit Shankar Prasad, Law Officer, Home Department, Shri Ajitab Kumar, ADG SCRB, Dr. Anant Prabhuji, Cyber Security Expert, Shri Pranav Shankar, Joint Registrar List, Patna High Court, for their contribution for comprehensively explaining the philosophy, structural changes, and nuances introduced by the new criminal laws, while emphasizing streamlined investigation, administrative and judicial procedures from registration of the FIR to the final judgment. I place on record our sincere gratitude to Shri Pratyay Amrit, Chief Secretary, Government of Bihar, whose address reinforced the importance of coordinated governance and institutional governance in translating legislative reforms into effective public administration. I respectfully thank Shri Satyadarshi Sanjay, Learned Advocate General Bihar, for his valuable presence and thoughtful address, highlighting the role of Bihar in ensuring effective implementation of the new criminal laws. Our sincere thanks are due to Shri Kundan Kumar, Secretary, Home Department, Bihar, for highlighting the administrative initiatives undertaken by the state government towards successful implementation of the new criminal laws. Our heartfelt thanks is due to Shri Dr. B. Rajender, Director General BIPARD, for his warm hospitality and for meaningfully collaborating with Bihar Judicial Academy in organizing this important state-level consultation. I would be failing in my duty if I did not acknowledge the invaluable support extended by respected Shri Pradeep Kumar Malik, Learned Principal District and Session Judge Gaya ji, for guiding and helping us in managing this program. I respectfully express our gratitude to respected Shri Shiv Gopal Mishra, Learned Registrar General, Patna High Court, whose constant guidance and cooperation greatly facilitated the successful planning and organization of this conference. We express deepest gratitude to District Magistrate Gaya ji for his ever-helping support in organizing this conference. I express our heartfelt thanks to Shri Dharminder Kumar Singh, respected Member Secretary, Bihar State Legal Services Authority, for gracing this conference with his esteemed presence. I express my deepest gratitude to Dr. Safina, Additional Director General BIPARD, for her sincere, devoted, and effortful contributions in organizing the conference. I, on behalf of myself and on behalf of Bihar Judicial Academy, sincerely thank Shri Santosh Kumar Singh, Senior Additional Director, and Shri Ajay Kumar Singh, Assistant Director BIPARD, for their unwavering support in making this conference successful. I feel deeply obliged to all esteemed officers and every member of organizing, protocol, hospitality, technical, documentation, transport, security, and entire BIPARD team for their silent yet dedicated efforts behind the scenes in making this conference a resounding success. Our sincere appreciation extends to every participant who has contributed to these deliberations through thoughtful interaction and meaningful exchange of ideas. I offer a special word of gratitude to all learned principal district and session judges, district and additional session judges, judges of special POCSO courts, chief judicial magistrate, all participating learned judicial officers, senior police officers, senior public prosecutors, officers from forensics who came from every district of Bihar, and all those esteemed judicial officers who joined us in these proceedings through virtual mode. Your enthusiastic participation reflects the collective resolve of judicial fraternity to ensure uniform, effective, and citizens-oriented implementation of new criminal laws throughout the state. I also place on record our heartfelt appreciation for the officers and members of High Court Registry and the entire team of Bihar State Legal Services Authority, the officers and members of Bihar Judicial Academy for their presence, for their support and cooperation. Our appreciation also extends to our friends from the print, electronic, and digital media for helping disseminating the objectives and outcomes of this significant initiative to a wider audience. At last, but not the least, we thank Team Welcome Hotel and Hotel Moria for serving us delicacies truly satisfying our taste buds. As we conclude, we carry with us not merely the proceedings of these 2 days, but a renewed sense of shared purpose. The successful implementation of new criminal laws is not the responsibility of any single institution. It is a collective constitutional endeavor founded upon cooperation, mutual trust, technological innovation, and an unwavering commitment to timely and quality justice. With these sentiments, I once again offer my respectful gratitude to every distinguished dignitary, every speaker, every participant, and every member of the organizing team for making this conference a memorable and meaningful success. Thank you, and sorry for being between the lunch. Thank you. Jai Hind.
With a vote of thanks, we have reached the conclusion of the 2-day state-level conference. Thank you all for your gracious presence.